What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast, and it's a big one today. We are going to break down in its entirety the appeal in the Maya Kowalski versus Johns Hopkins All Children's Hospital case, where they overturned and threw out the entire jury verdict, $200+ million. We've talked about some of the infighting with the plaintiff's attorneys. We'll talk about how this appellate decision is going to affect that, among other things. We'll talk about what it means for the verdicts, the dollars that were given last time, what it means for a potential future trial, why it happened like this, where I agree with the appellate court, where I disagree with the appellate court. It is a 47-page opinion, and we are going to read every page. It includes a concurring opinion, which is incredibly interesting on its own. But in order to be able to break this down, and I feel like think and process appropriately and not lose my voice throughout, I'm going to bring on a special guest. We are going to hear from John Nizer, the producer of this show. He is going to actually read the pages. I will stop him and interrupt him and explain what's going on and answer a lot of the questions you guys have already brought in. He also has some questions. He followed this trial, was working on the channel when it was happening as well. So we'll answer his questions, and he's going to be kind of a nice proxy for you. But if you guys want to, because I know this is a podcast and a lot of you are listening on audio form, if you have a ton of questions, we can do a follow-up entire live Q&A on this topic. It's just kind of impossible to break down 50 pages and do a Q&A at the same time. So we're going to break it up into two videos, and we're going to break down the entire appellate decision here, give you all of my thoughts and opinions, and then maybe we'll have a second follow-up if you guys want that. Write in the comments you want a Q&A on this one and hit that like button. Let's get into it. Welcome in, John. Thank you for doing God's work here and reading this to us. And, for all the people that think my voice is annoying, you'll enjoy this as well, getting to hear a different voice, read the words on the page here, because we have the District Court of Appeal of Florida, 2nd District, which is my district. Like we try cases all over, but obviously my normal Pinellas County, where I live, where our office is, this is the District Court of Appeals that would hear our cases, that heard our recent appeal and gave us a very quick win on our last one. So it's not like I hate this DCA or the judges there. I have friends all over the state that are either related to or that are appellate court judges. And so, any of my thoughts about how they handled this case is not necessarily about any individual judge or the appellate court in its entirety, but there are going to be some things I very seriously disagree with what they did here. And I think that some of the overarching topics here that we need to talk about throughout is, what is the role of an appellate court versus the jury? And once you have a jury verdict, what is an appellate court supposed to do? They explain that here a bit, and then I think they kind of lose their way a little bit as we go. And we're also going to obviously talk about how this affects Maya's case and her family's case going forward. What can they do? What will her lawyers do to respond? What will the defense lawyers do to respond? What else can they do now that they've lost here? We're going to make sure we put all of that in here. But in Florida right now, and it's happening in other states too, but there is a serious push and influx of big companies, whether it's insurance companies, hospitals, the lobbyist groups for doctors, protecting doctors. They all spend more money lobbying, changing the law, and affecting the justices that are appointed to all these higher courts, to where they are very much going in a certain direction. And this decision highlights the direction they're going in. I'm going to touch on that as we go as well. But there is absolutely this double-edged sword for attorneys and claimants that have claims like this against big companies, whether it's a hospital or insurance company, that if you lose, you lose. But sometimes if you win too big, you lose. And that's something we talked about when this verdict first came down, that this is so huge. And I think the judge did them a favor cutting down the money amount when he did that after this verdict was given, because a lot of these appellate court judges and where the law is going in Florida is going to hate a $200+ million verdict against a hospital. And guess what? That is gone. And this is going to create so much leverage, not just for the defense in this case, but in so many other cases where claimants have very legitimate claims. Obviously, there's frivolous claims. Obviously, there's people trying to get rich quick and, make a claim that's totally false to get some money in their pocket. I agree. I'm not talking about those claims. This will absolutely affect legitimate claims like Maya Kowalski had. Her life was negatively affected by what J. Hatch did. And now this is turning it on its head. And we'll talk about, what she has and what she can possibly do in the future. But this is the appeal decision, John, and we can kind of jump to page 2, where we start the beginning of the decision and the breakdown background of what's going on. unless you have any questions before we start.
Yeah, no, I just need to, I guess, warm up my vocal cords here.
Buckle up.
You ready?
Yep, let's do it.
Let's do it. So, right here from page 2, Johns Hopkins All Children's Hospital, Inc., JHatch, appeals from the final judgment rendered against it and in favor of Maya Kowalski, Jack Kowalski, and the estate of Beata Kowalski, collectively the Kowalskis. The final judgment awarded damages to the Kowalskis for the false imprisonment between October 7th and October 13th, 2016. Intentional infliction of emotional distress, wrongful death for intentional infliction of emotional distress, false imprisonment between October 18th and October 20th, 2016, false imprisonment on January 6th, 2017, medical negligence, battery on January 6th, 2017, battery for unspecified dates, and fraudulent billing. The trial court's erroneous interpretation and application of Section 39.203(1)A Florida Statutes 2016 and the immunity afforded thereunder, as well as the trial court's erroneous denial of JHatch's motions for directed verdicts and JHatch's motion for a new trial, require reversal of the final judgment.
All right, so let's pause right there for a second before we get into the background. And the background is going to be kind of factually what happened in this case. Some people know exactly what happened, but it is really, really, really important for us to read this because this is going to be the background as the appellate court sees it, which is supposed to be from the trial record and should be read in the light most favorable to Maya and her family. But when we look at what they did, the crux of the entirety of turning this case on its head is that we feel that Judge Carroll was erroneous in his interpretation and application of Section 39.231A, which is the immunity for the reporting that we're going to get into. And because he made the wrong call there, they have thrown everything out or remanded anything that's left for a completely new trial, rendering everything this jury did a complete waste and worthless because they got to hear and consider evidence that they should never have heard. That's the crux of this entire appellate issue or this entire appellate order and why it's been flipped on its head because it permeated through the entire trial and the jury was enraged, probably added damages, ruled in favor of Maya because of information they heard that they should have never heard. It happened to her. She suffered through it, but this court feels that the state and JHatch should have been immune based on this statute and its immunity. So we're going to parse this out. It's not as simple as it may seem. And there is nuance in the law, and judges can give and take when it comes to what's appropriate for the jury to hear, what's not, what should you be protected from doing, and what should you not be protected from doing. But first, let's see how the court looks at the background and the facts of the case.
In the fall of 2015, Maya Kowalski was diagnosed with complex regional pain syndrome, CRPS. Beata Kowalski, Maya's mother and a nurse infusionist, became aware of CRPS prior to Maya's diagnosis through one of Mrs. Kowalski's patients. CRPS is a central nervous system disorder. It is characterized by severe regional pain with no apparent cause. Patients with CRPS experience an array of symptoms, including agonizing pain in the affected region or limb, extreme sensitivity to touch, light sensitivity, and lesions. Intentional treatments for Maya's CRPS included warm water.
Initial treatments. It's initial treatment. It's not intentional, but yeah, because it's leading up to how does this start? How does this begin? And even with that first part about the mom became aware of CRPS through another patient. You can see where they're starting to go, right? She became aware of CRPS, and now Maya has it. That's how they're writing these facts.
Initial treatments for Maya's CRPS included warm water therapy, physical therapy, non-narcotic pain medications, and opioids. When the initial treatments failed to relieve Maya's pain and symptoms, Maya began receiving ketamine. This included Mrs. Kowalski taking Maya to Mexico, where Maya was placed in a 5-day ketamine coma for a period of approximately 8 months prior to her admission to JHatch in October 2016. Maya was being treated with ketamine infusions through a central venous port in her chest. The ketamine infusions were authorized and overseen by Dr. Ashraf Hanna, a pain management doctor.
Hanna is fine. You can just call him Dr. Hanna or Hannah. I think it's actually Hannah is how people said it throughout the trial.
A pain management doctor. Although ketamine had been the longest used and most successful treatment for Maya's CRPS prior to her admission to JHatch, Maya's physicians had also prescribed other treatments, including hyperbaric oxygen and immune system stimulants. During most, if not the entirety, of her treatment, Maya was unable to walk without assistance and was in a wheelchair. On the day before Maya's admission to J Hatch, Dr. Hanna advised Mrs. Kowalski that he had given Maya the maximum dosage of ketamine that could be administered and that it was not helping Maya. Dr. Hanna advised that Maya be taken to J Hatch. On October 7th, 2016, Mr. Kowalski brought Maya, then 10 years old, to the emergency room of J Hatch. Maya
All right, hold
presented.
on.
Go ahead.
Pause for a second. So the footnote here is Dr. Hanna did not testify at trial. And that to me is interesting. And I'll read the footnotes kind of as we go when I think they're necessary to comment on. But the court is pointing that out. J Hatch could have called him too, and they didn't. But they pointed out here. So I just want to highlight that.
Maya presented with excruciating pain. Upon Mrs. Kowalski's arrival at J Hatch, she was adamant that Maya received ketamine infusions. And although J Hatch was unable to confirm with Dr. Hanna that Maya had been in his care and had been receiving high dosages of ketamine, the hospital emergency room notes state that dosages at the level demanded by Mrs. Kowalski could not be administered in the ER. Maya was ultimately admitted to the pediatric intensive care unit at J Hatch, PICU. Concerned about Mrs. Kowalski's demands for ketamine and perceived inconsistencies between Mrs. Kowalski's recitation of Maya's medical history and J Hatch's own observations, a social worker at J Hatch, in accordance with J Hatch's policy, called the Department of Children and Families Abuse Hotline on October 7th, 2016. The following day, October 8th, 2016, J Hatch contacted Dr. Sally Smith because of the suspected abuse. Dr. Smith, who had privileges at J Hatch, is a pediatrician and was the medical doctor at the Child Protection Team for Pinellas County at that time.
Hold on. Medical director. She was the medical director at that time, and that's going to be important because we're going to talk about whether or not Sally Smith was an agent of J Hatch at the time and get into how this court kind of parses that out. But so far, if you suspect it, if you suspect abuse, you call the hotline. Absolutely what you should do. We need those protections in Florida, and there should be immunities attached to that. Okay, that is important.
On October 9th, 2016, a second call from a social worker at J Hatch was made to the Department Child Abuse Hotline. This second call resulted in an immediate investigation. On October 13th, 2016, Maya remained at J Hatch but was taken into the department's custody. The department filed a dependency shelter petition requesting that Maya be placed in the shelter care of the department because Maya had been abused, abandoned, or neglected, or was in imminent danger of abuse, abandonment, or neglect. The department sought medical shelter care for Maya and requested no contact between Maya and Mrs. Kowalski, but supervised visits between Maya and Mr. Kowalski and Maya's brother. On October 14th, 2016, following a hearing on the department's petition, Maya was placed in the shelter care of the department. The dependency court order provided that Mrs. Kowalski was to have no contact with Maya pending psychological evaluations of both Mrs. Kowalski and Maya. The order.
All right, so pause.
Go ahead.
So now when we start to get into court orders and the hospital can't do certain things because of what the court is saying, there should be some immunity there. But if you listen to what the court ordered and what J Hatch did, and the differences, in my opinion, should absolutely be relevant and available for the jury. We'll talk about what some of those are. Also, there's going to be some words of self-harm coming up, and just use self-harm instead of the words they use here so we don't get dinged here.
Okay. The order further provided that the department would make all efforts to identify an appropriate person at J Hatch to supervise visitations between Mr. Kowalski and Maya. Additionally, the order provided that in the event Maya's parents were unwilling, the department or the person primarily responsible of sick,
that just is like a different way to say it. You don't have to read that.
Okay. The person primarily responsible of the care management of Maya was authorized to consent to ordinary and necessary medical examination and treatment of Maya. Thus, as of October 13th, 2016, Maya was in the custody of the department, and beginning on October 14th, 2016, Maya was under the jurisdiction of the dependency court. At trial, Mr. Kowalski testified that at some point between October 8th and 13th, 2016, he and Mrs. Kowalski requested that Maya be released from J Hatch, and the J Hatch subsequently threatened them with arrest if Maya were to leave the hospital against medical advice. Mr. Kowalski testified that J. Hatch advised him that Maya could not leave the hospital because Maya had to be safely weaned off medications, including ketamine. Evidence at trial established that J. Hatch attempted to transfer Maya to another hospital, but that the Kowalskis would not consent to the transfer because the insurance codes on the transfer form indicated that Maya had Munchausen syndrome or conversion disorder, or was the target of Munchausen syndrome by proxy, and did not indicate that Maya was suffering with CRPS. Mr. Kowalski testified that he and Mrs. Kowalski would not sign the transfer form because they believed it would mean admitting guilt or blame.
I'm a seafood lover. I don't know if you guys are as well, but it's really difficult sometimes to find seafood that you can trust from a nutrition, sustainability, and taste standpoint. Well, Wild Alaskan Company is my go to, and they're a sponsor of this channel now. They are by far the best way to get wild caught, perfectly portioned, nutrient dense seafood delivered directly to your door. Trust me, you have never tasted fish this good. And you can always trust that they're 100% wild caught, never farmed. This means no antibiotics, GMOs, or additives, just clean, real fish that support healthy oceans and fishing communities. One way you know you can trust it is when you have a 100% money back guarantee. So if you're not completely satisfied with your first box, Wild Alaskan Company will give you a full refund, no questions asked, no risk, just high quality seafood. Not all fish are the same. Get seafood you can trust. Go to wildalaskan.com/lawyer for $35 off your first box of premium wild caught seafood. That's wildalaskan.com/lawyer for $35 off your first order. Thanks to Wild Alaskan Company for sponsoring this episode. So let's pause there and read a couple of the footnotes. So the one above says, Section 39 defined necessary medical treatment as the care which is necessary within a reasonable degree of medical certainty to prevent the deterioration of a child's condition or to alleviate immediate pain of a child. So they're really going to do everything they can, the appellate court, to broaden that definition. And then the last paragraph you just read had footnote 4, which said, evidence established that prior to Maya's admission to JHatch in October of 2016, concerns had been raised about psychological factors affecting Maya's physical condition by medical professionals who had treated Maya at Tampa General Hospital and Lurie Children's Hospital of Chicago. So again, it's almost this almost feels like an oral argument in the form of an order from the appellate court and how they're setting this up, in my opinion. All right, go ahead.
Without referencing the limitations and requirements of the dependency court orders, Mr. Kowalski testified that anything that he brought into the hospital had to be approved, whether it was clothing, food, or letters. Food was required to be prepackaged and could not be homemade.
All right, so let's pause there.
Sure.
That goes in line with, maybe they're poisoning her, maybe they're keeping her sick. We want to stop that from happening. Although really it was all blamed on Mrs. Kowalski, not Mr. Kowalski, but still, they didn't want them to bring anything cooked, which I understand that. I don't have a problem with that.
Mr. Kowalski testified that during one of his visits, Maya had asked him whether Mrs. Kowalski was in a mental institution. When Mr. Kowalski asked why Maya would say that, Maya told him that a JHatch social worker assigned to Maya, Catherine Betty, had told Maya that Mrs. Kowalski was receiving mental health treatment.
All right, hold. That's pronounced Beatty, just for the future. And this is when we start to get into, okay, they felt like they needed to cut her off from her mom, which again, that's a court decision. And there was only supervised visits with Mr. Kowalski. Okay, fine. But what Catherine Beatty said to Maya, how she acted towards Maya, if it was inappropriate, in my opinion, there's no way that should be covered under immunity. That's like saying, okay, Beatty is going to be in charge of Maya. The court's saying she can't have any interaction with her mom or her dad, whatever it may be. And she does all these things to abuse Maya. But guess what? Rule 39 absolves her from all immunity. It can't possibly be like that. So in my opinion, Judge Carroll is still going to have to parse what can and can't be argued as appropriately performing the procedures and the responsibilities, even within the court order, even within the sheltering at the hospital, even with the quote unquote protection of Maya. Because making her feel badly about her mom, speaking poorly about her mom to her is totally inappropriate, not necessary, not something that's done for the protection of the child. So how far are we really going to put this blanket over it? And are we just going to let hospitals and the state take control of our kids because there's an allegation of abuse? Like, this is such a slippery slope to me that it's really dangerous and I'm not loving it. You can miss me with this if you're going to let the state and hospitals make decisions for my kids. And you could say, Peter, you're a good parent. It's different. I get it. It's hard for us to fathom that there are bad parents out there, but there are. It's hard for us to fathom that there are parents that would want to hurt their kids, but there are. Okay, it absolutely does exist. But even here, it seems like they realize Mr. Kowalski is not doing that, yet they're taking such control and doing things to Maya that are so inappropriate that to me, that's exactly why we have the civil justice system, to be able to push back and make sure hospitals never do something like this again and have more appropriate procedures in place when there is a Rule 39 situation and they need to make these tough decisions and they need to protect children. Let's do it the right way and not in an abusive way.
Just a quick question, because you brought up Judge Carroll. So this is still a case that he sits over. This isn't something that gets kicked to a different judge or something to that effect. It's still a case that he will oversee regardless of how this moves forward from this point.
Correct. The judges rotate sometimes or retire or whatever for something like that, but it's not like because his decision was overturned that it goes to somebody else. He will still be the decision maker, and because it's such a complex case, frankly, for judicial economy, it only makes sense that he would continue to handle this case as opposed to a new judge coming in and trying to learn it.
Makes sense. Where are we here? Mr. Kowalski testified to additional statements made to him by Maya, including instances where nurses had told Maya that her illness was all in her head, and where Miss Beatty had told Maya that she could be Maya's mother while Maya is there at the hospital.
Again, further examples of things that are totally inappropriate, that are abusive, in my opinion, that we have to call out, that we have to stop in hospitals. We cannot possibly allow this type of treatment to go on under the guise of Rule 39 protection.
Mr. Kowalski also testified regarding his own interaction with Miss Beatty, wherein she asked him, "Did you ever consider divorcing your wife?" He responded, "What are you talking about?" And Miss Beatty said, "Oh, forget it," and walked away. Mr. Kowalski relayed to Mrs. Kowalski what had happened during his visits with Maya and the information he had learned. Although he was aware that Maya had been moved to a new room on October 18th, 2016, Mr. Kowalski testified that he was unaware that the new room identified by JHatch staff by JHatch staff as the EEG room, was under video surveillance until many years after the fact. He testified that he never saw Maya mistreated.
Hold on a second. Let me read the footnote there. JHatch's admission form includes the following language. I understand that closed circuit television monitoring of patients' care may be used during the course of treatment. So this is the appellate court using the fine print and saying that's totally appropriate. JHatch let you know. No reason for them to actually tell you or try to keep you up to date on what's going on with your kid, which is fine. And that's how a jury could look at it. But this is one of the instances where, in my opinion, the appellate court is starting to enter the province of the jury and say, well, look, this is a fact that should have made the difference and should have made a jury disregard. Can you hear that plane flying over me? No, it's like crazy loud here. Like it feels like a bomber plane flying over me.
There's one over here
but
too.
You can hear it there.
The same
but yeah, it is. But anyways, as I was saying, like these are the situations where it sounds like this appellate court is coming in and saying, hey, this fine print that the jury did not consider enough to throw this out, they should have, and this is a fact we disagree with how the jury looks at it. And that's where I have a problem with there. Now, the Rule 39 stuff, we can disagree with how they apply it, but that's a legal question. And if the court says the judge missed on how he applied Rule 39, and therefore it affected the entire prism of the trial and the entire way the jury saw the trial, that is the role of the appellate court. You made a legal error, Judge Carroll. We have to go back and fix it because the jury heard all sorts of things that they should not have heard. But to go to facts and say the jury didn't consider this appropriately, or no reasonable juror could have found that the fine print was not enough of a notice to Mr. Kowalski, is not appropriate for the appellate court, in my opinion.
He testified that he never saw Maya mistreated. Likewise, he never saw nurses taking actions that he considered to be cold or unusual. Maya testified at trial that the commode in the EEG room was far enough from the bed that she would have to stand up and walk to use it, which she could not do. Maya believed that the nurses wanted to provoke her in order to prove that she could walk.
And again, this is another thing where if you think somebody's faking it, you put them in positions to, show that they're faking it. That's, somewhat reasonable, but also if they actually prove that they can't, and now they're soiling their sheets and things like that, it's like, at what point does a 10-year-old kid, do you help them go to the bathroom?
Maya Maya testified that she was not permitted to speak with her mother and that this infuriated her. Although Maya was told that her pain was in her head and that she was making it up, Maya testified that she was not told that physicians believed she had conversion disorder or Munchausen syndrome. One instance Maya relayed involved a specific nurse verbally accosting her for not moving during a bed change. Despite Maya advising the nurse that she could not walk, stand, or roll, the nurse said, "If you don't move right now or else." She recalled that the nurse yelled at her for quite a while, saying, "I know you can move. I know you're faking it. Just stand up. We all know." The
Okay.
Kowalski.
So
Good.
So even more examples of abusive language. And I'll just tell you right now, and I think this is probably what happened on the jury. All of us have been to the hospital before. All of us have had doctors or nurses that are rude and horrible to us. When I was a kid, I was in the hospital in high school, multiple surgeries on my broken leg. My mom was there every single day. If anybody said something horrible to me, my mom was jumping in. My mom was making sure they were doing everything appropriately. I remember they put the first cast on my leg, and I was like, it hurts so bad, and nobody would listen to me. My mom wouldn't stop, and so they come in, they cut the cast off, and there was like a metal like splint that was pointed in, and it was literally pressing right where my broken leg was, and they never would have opened it up if I would have kept asking them, but my mom did. Well, guess who wasn't there for Maya? Her mom. So for them to treat her like this with no parents around, to me, is not something that should be cloaked in Rule 39. And that like, what does that have to do with separating her from her mom and protecting her? It's the opposite. It's adding insult to injury. It's not protecting her from an abusive parent. And that's, I think, things that should be able to still be argued to the jury that I'm afraid will not be based on this court's ruling.
The Kowalskis are Catholic, and Maya testified that she was not permitted to receive communion from her parish priest. She did receive communion from a priest associated with JHatch. Maya believed that
Okay.
outside food,
Sorry.
including the communion water, was not permitted because there was a fear that Mrs. Kowalski would tamper with it or somehow add ketamine to it. She did
Okay,
not
hold on. Hold on. So that's another one that, to me, if you're religious, right? I'm not Catholic. I know a lot of Catholics. I know what a big deal this is. Why did you have to have the hospital priest? Like, the priest is now in on it. The hospital, or Maya's priest could have brought prepackaged communion, the bread and the wine or juice, or gotten it from the hospital if they really wanted to make sure that it was okay. But still, she could have felt the comfort of her own parish priest that she knew. But once again, this to me is so overboard and abusing the immunity and authority that was given to the hospital. And that's kind of the point of this case: is how far are they allowed to go under this immunity? And I think the jury answered the question. They went way too far. But this court is stepping in and saying, nope, they did what they're allowed to do. And that's scary.
She did not testify to the requirements of the dependency court orders in this regard. Maya reiterated in her own testimony that Miss Beatty had told her that Mrs. Kowalski was in a mental institution. Maya quickly learned that Miss Beatty's statement was false, and Maya believed the statement was intended to manipulate Maya into thinking that her mother was sick and therefore making Maya sick. Maya also reiterated that Miss Beatty told her, "I'm not trying to be your mother, but I can be." Mrs. Kowalski was born in Poland, and Maya often spoke in Polish with her mother before her admission to JHatch. Although the dependency court eventually permitted Mrs. Kowalski to have supervised phone and FaceTime calls with Maya, Maya was not permitted to speak Polish with her mother, and the calls were limited to basic and insignificant things. An audio recording was played of one conversation where a female voice advised Mrs. Kowalski that we are not allowed to talk about the dependency case. After Mrs. Kowalski told Maya that as soon as the judge makes the decision, she would be able to see Maya again. A final instance involving Miss Beatty occurred when Miss Beatty took photographs of Maya before Maya left the hospital for a dependency court hearing on January 6th, 2017. Maya testified that Miss Beatty came to Maya's room and told Maya that if Maya wanted to go to court, she was going to have to be stripped naked and photographed. Miss Beatty and a nurse did photograph Maya before court. Maya was wearing a training bra and shorts in the photographs. She understood that the photos were for purposes of the dependency case.
Okay, pause. So again, the court putting their version of how they view the events, which to me don't feel like they're in the light most favorable to Maya and to what the jury has already decided. And you can feel it in the language of this factual background. I can, at least. You guys let me know in the comments if you feel it. Fall is absolutely my favorite time of year, but it's also the busiest time by far. We are in the thick of it now with holidays and trips and school and work. And so time is of the essence. And any way you can save time, you've got to do it. And that's where today's sponsor, Green Chef, comes in because they make it easy to spend less time in the kitchen and more time enjoying the fall, the trips, the holidays, the time with family. And now they even have their heat and eat meals, which are delicious, wholesome meals in just 3 minutes, which is crazy that you can have a meal like this that quickly. And as always, Green Chef is really customizable for whatever you are looking for. If it's a wellness journey or a specific kind of food you're looking to eat, they have real clean ingredients that help you build lasting, healthy habits. Make this fall your healthiest yet with Green Chef. Head to greenchef.com/50LYK and use code 50LYK to get 50% off your first month, then 20% off for 2 months with free shipping. That's code 50LYK at greenchef.com/50LYK.
Maya testified that she was in worse condition when she was released from JHatch in January 2017 than when she was admitted. She also testified that by her 7th and 8th grade years in school, August 2018 through May 20, she was participating in physical activities without restrictions. Miss Beatty's deposition was played for the jury. She testified that she was a licensed clinical social worker at JHatch at the time of Maya's admission. Miss Beatty testified that she was required to follow the dependency court shelter orders and that it was the dependency court that determined who Maya could see and when. She also testified that court orders provided general parameters, but that the department and JHatch, to some extent, determined how to implement those parameters. Miss Beatty testified concerning the initial calls to the department abuse hotline and the rationale behind those calls. She also testified that 95% of the time that she saw Maya, Maya was up in her wheelchair, and that in the times that she would report extraordinary pain would be when she was prompted by her mother or if someone asked her if she was having pain. She further testified that JHatch noted on several occasions where Maya was moving her legs, moving her hands without any pain. Maya was engaging in activities such as foosball, cutting out and making crafts in the craft room. She was out playing the piano downstairs and often moved herself around the hospital. It was only after we gave the information to the department that Maya then decided or quit moving herself around the hospital for days.
Okay, hold on. The footnote there is much of Ms. Beatty's testimony concerned actions authorized or required by Chapter 39 and responses to questions mischaracterizing JHatch's continued involvement as taking this child away from her parents. So again, Ms. Beatty, who they're already putting in the factual background, told Maya she could be her mom, asked Mr. Kowalski if he was going to get divorced, told Maya, according to Maya, again, if I'm looking at the facts in the light most favorable to Maya and looking at what the jury did, that her mom was in a mental institution, that if she didn't do this right, she had to do this right now or else, and other people telling her that she was faking, and Miss Beatty taking pictures of her and telling her to strip naked and things like that, and the inappropriate conversations about, sitting on her lap or whatever it was, basically trying to be Maya's mom. Hold on a second. Excuse me, I had to sneeze there. They're just like, the appellate court's like, well, much of her actions were authorized or required by Rule 39. It's like, I disagree. I seriously disagree that all of that is authorized or required by Chapter 39. Now, supervising the phone calls, sure. Telling Maya they had to take a picture to make sure there's no injuries to her or at least inspect her prior to going to court, sure. Like there are aspects of her actions that are covered under Rule 39, but it's not just like, and I don't know how many different ways I can say this, but it's not saying you have to separate somebody from their mom, you have to supervise phone calls, and then that would authorize you to hold them down in bed, sit on top of them, and scream at them the whole time because you're doing it in the essence or in the vein of, well, I'm keeping them from their mom, which is what's required or authorized by Rule 39. It's totally unfair.
In one of her case notes, Miss Beatty wrote, Maya told me she was furious, angry, and in pain. She told me she can't talk or trust anyone, that she knows there is court on Monday and it's all lies. Ms. Beatty testified that JHatch has a policy against recording phone calls and that therefore objected to Mrs. Kowalski recording calls with Ms. Beatty. She also testified that whether Maya was permitted to see her priest was up to the dependency court. Ms. Beatty testified that the department asked that JHatch monitor Maya's calls and that at times calls came through Ms. Beatty's phone and she would put her phone on speaker to allow Maya to have the conversation. Ms. Beatty supervised phone calls between Maya and Mrs. Kowalski once the dependency court supervised limited contact. At no time did the dependency court authorize in-person visitation between Maya and Mrs. Kowalski. Ms. Beatty testified that in January 2017, J. Hatch's risk management department asked Ms. Beatty and another person to take photographs of Maya before she was taken to a January 6th dependency court hearing. The request for photographs had been made by an attending physician at J. Hatch. Ms. Beatty testified that in the professional context and in the foster care program, photographs are taken if there are injuries. She confirmed that at the time of photographs, Maya was in the custody of the department and that the department was getting ready to take their own pictures as well. No one explained to Ms. Beatty why she was taking the photographs of Maya. Ms. Beatty noted that the email she received addressed concerns that Maya was self-harming and had scratches on her body. On January 6, 2017, the dependency court ordered that Maya would remain sheltered at J. Hatch and set a February 2017 trial date. Mrs. Kowalski self-harmed the following day, January 7th, 2017, leaving 2 self-harm notes. Those notes
All right,
reflect...
just to clarify the difference between the self-harms, Ms. Kowalski ended her own life. Maya's self-harm was different. But now we're getting into the facts surrounding Beata Kowalski ending her own life, which was a big point of contention from the jump. This was always the most difficult claim to go forward on, and that I was kind of surprised they were able to go forward on. And there are times in civil cases where lawyers think we just need to get this to a jury. We just need to get past summary judgment because we know it's so bad and the jury's going to hate them so much that they're going to give a big number. And I do think this had that effect. And I do think that this appellate court was like, absolutely not when it comes to this claim. And it could have potentially affected the way they looked at the other claims. So this was always kind of a long shot to me. I know people kind of disagreed with me about that, when the case was ongoing, but to try and connect somebody else's intentional self-harm to the actions of another probably would have to be more connected than this. So this is one of the areas I probably agree with the appellate court. Although I do think that Maya's team and the lawyers did do a pretty good job connecting this up. Just imagine the floodgates it would open and the issues and the precedent it would send. It would send that if something's going on horribly with your child and you hurt yourself, that your child could end up getting a lot of money if somebody was mean to them or wronged them or did something to them, and it caused you so much emotional damage, to give people more incentive to hurt themselves so that a loved one may benefit from it. I don't think we want to do that as a society or a state or a justice system. So I do understand their position here with the self-harm that we're going to listen to as the order goes on.
Those notes reflect Mrs. Kowalski's sadness and frustration with the dependency court proceedings and those involved with the dependency proceedings, including J. Hatch and the department and Dr. Smith. 1 week after Mrs. Kowalski's self-harm event on January 13th, 2017, the dependency court allowed Maya to be released from J. Hatch and to resume living with Mr. Kowalski.
All right, so pause there again. So again, this is more indication that Mr. Kowalski was fine, Mrs. Kowalski was the problem, yet they had to do such a crazy job blocking Maya from her priest and from everybody else, when immediately when Mrs. Kowalski is removed from the situation, she's back at home. So she can see her priest, she can eat food from the house, she can be left with Mr. Kowalski. So to me, it's just highlighting all sorts of problems with this entire procedure. And then again, when you look up what you just read, that those notes reflect Ms. Kowalski's sadness and frustration with the dependency court and those involved in the dependency proceeding. So this appellate court is connecting J. Hatch, department, Dr. Smith with the dependency proceedings on purpose because they're trying to limit all of this wrongdoing that the jury found, obviously, and that a lot of the public finds that this is unacceptable. But they're like, well, it's all part of the dependency, so therefore Rule 39 covers it.
The dependency case was ultimately dismissed during the months that Maya was sheltered at J. Hatch. She was weaned off ketamine, and the dependency court order releasing Maya from J. Hatch prohibited additional ketamine treatments. Maya had been admitted to J. Hatch in severe pain, unable to walk, and receiving high doses of ketamine when she was discharged from J. Hatch. She was still in significant pain and unable to walk. At the time of trial, the only medication she routinely took were Claritin, Flonase, and a sleep aid. She had been able to walk, run, and ice skate. Maya testified that she had experienced no CRPS flare-ups in the 3 years following her January 2017 discharge from J. Hatch.
Time out. That sounds like they're literally reading the end of the defense's closing argument. She was in severe pain, unable to walk, receiving high doses of ketamine. Then when she left, she was still in pain and unable to walk. But in the time since, when they didn't say this, but when Beata Kowalski's out of the situation, now she's fine. She can run, she can sleep, she takes a sleep aid, but she can run, walk, and ice skate. So again, I don't disagree with their version and how they view this. But to me, this colors the way they look at everything. It seems to me this appellate court has looked into this case and they disagree with the jury. They think that there was a problem with the ketamine. There was a problem with Beata Kowalski and how she handled Maya, and she's better off without Beata Kowalski, and J Hatch shouldn't have to pay for that because J Hatch actually helped her. As I'm reading the facts, it sounds like they're agreeing with the defense and not the jury in the way they're writing a lot of these facts. That's what it sounds like to me.
Absolutely, yes.
Okay, go ahead.
The Kowalskis filed their lawsuit on October 5th, 2018. The operative 8th amended complaint was filed on January 24th, 2023. More than 50 pretrial motions were litigated and resolved before this legally complex and emotionally charged case was heard by a jury beginning on September 14th, 2023. During the 2-month trial, additional motions were filed and resolved, including multiple motions for directed verdicts. On November 9th, 2023, the jury returned a verdict in favor of the Kowalskis on all remaining claims. Post-verdict, J Hatch filed an omnibus
Yeah.
renewed motion for directed verdict, motion for new trial, and motion for remittitor. The court denied largely, without elaboration, the renewed motion for direct verdict and motion for new trial. It granted in part the motion for remitter. The court then entered the final judgment. So Section 2, analysis. Standards of review. Issues of statutory interpretation are reviewed de novo. A trial court's decision on a motion for directed verdict presents a question of law, the sufficiency of a party's evidence that we review de novo.
Which de novo just means anew. Just you're like looking at it for the first time. It's fresh.
Okay.
They don't give any deference. They don't give any deference to the lower court's rulings. They look at the arguments and the facts, and they're going to make their own decision, basically. They don't have to say you were right and it's got to be egregious, or abuse of discretion, things like that.
When considering whether the trial court should have granted a directed verdict, we must evaluate the testimony in the light most favorable to the non-moving party, and every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party.
Which in this case, the non-moving party is Maya and her family.
Our review of the denial of a motion for new trial is for an abuse of discretion. In reviewing an order.
So that's the difference, right? De novo versus abuse of discretion. Abuse of discretion, you have to kind of assume it's right unless they abused their discretion, hence the name. De novo is you're kind of looking at it blank slate.
In reviewing an order on a motion for a new trial, an appellate court should consider the totality of all errors and improprieties. Pre-trial, J Hatch moved for
Hold on. So that this is actually a section here. So B is the next paragraph or the next section we're looking at. And this is going to be, like I said, the crux, the Section 39 immunity, because they're saying the judge's screw up on this order bleeds into the entire case, which is why they didn't just throw out one count or one verdict or one amount of money, but they kind of have thrown out everything, and some cannot even be brought again in trial and some can. So this is theoretically the most important paragraph as to why this entire thing was flipped on its head.
Pre-trial, J Hatch moved for a partial summary judgment based on the immunity afforded pursuant to Section 39-203. J Hatch argued, as relevant to this appeal, that every claim against it, except the battery claims, was precluded as a matter of law because J Hatch had reasonable cause to report suspected child abuse and was otherwise participating in Chapter 39 proceedings. The trial court granted in part and denied in part the motion based on its interpretation and application of Section 39-203 to the Kowalski's claims. J Hatch argued in its post-verdict motions that a new trial is warranted based on the trial court's narrow interpretation and erroneous application of the statutory immunity. On appeal, J Hatch again seeks a new trial based on the court's erroneous rulings with regard to Section 39-203(1)(a) and the pervasive impact on the trial. The trial court considered two sections of Chapter 39 and applicable precedent addressing the statutory language. Section 39201 addresses mandatory reporting of child abuse and provides, in relevant part, any person who knows or has reasonable cause to suspect that a child is abused, abandoned, or neglected by a parent shall report such knowledge or suspicion to the department in the manner prescribed by subsection. Physicians, nurses, and hospital personnel engaged in the admission, examination, care, or treatment of persons, as well as other health or mental health professionals, are required to provide their names to the abuse hotline when making a report. Suspected child abuse by a parent must be reported immediately, and any person who is required to report known or suspected child abuse and who fails to do so commits a felony. Section 39203 addresses actions authorized or required by Chapter 39, as well as reporting child abuse, and provides any person, official, or institution participating in good faith in any act authorized or required by this chapter, or reporting in good faith any instance of child abuse, abandonment, or neglect to the department or any law enforcement agency, shall be immune from any civil or criminally liable or criminal liability which might otherwise result by reason of such action.
I love being an entrepreneur, but whether you're starting a small business or already running a small business, you want to focus on the business, the sales, the growth, the product, the service itself. You don't want to be focusing on payroll and HR tasks, but that is a major part of running a successful business. And today's sponsor, Gusto, is the perfect fit for your small business. Gusto is an online payroll and benefits software built for small businesses. It's all-in-one, remote-friendly, and incredibly easy to use. So you can pay, hire, onboard, and support your team from anywhere. Those are checking all of the boxes for what I personally think are the most miserable parts of running a business. And you can get direct access to certified HR experts to help support you through any tough HR situations, because usually you're not an expert in that. Plus, don't pay a cent until you run your first payroll. So try Gusto today at gusto.com/LYK and get 3 free months when you run your first payroll. That's 3 months of free payroll at gusto.com/LYK. One more time, that's gusto.com/LYK. Okay, so now is where we're starting to get into what are the actions that should be protected versus the ones that shouldn't. Because it clearly doesn't mean now that we're in this situation, you can do whatever you want. Clearly doesn't mean that.
In considering Section 39201, the trial court also considered both cases addressed only reports of suspected child abuse and the immunity afforded thereto. In one case, the court concluded that there are 2 ways in which a doctor can be immune from civil liability for making an incorrect report of child abuse. Immunity exists as a matter of law if the doctor has reasonable cause to suspect that the child has been abused and makes a report of the abuse as required by law. In that event, there is no need to determine whether the doctor acted in good faith. Once reasonable cause has been shown, a reporter complying with the statutory mandate to make a blank, if it appears that the immediate safety or well-being of a child is endangered, the family may flee or the child will be unavailable for the purposes of conducting a child protective investigation, or that the facts otherwise so warrant. The department shall commence an investigation immediately, regardless of the time of day or night. In all other children abuse, abandonment, or neglect cases, a child protective investigation shall be commenced within 24 hours after the receipt of the report. The shelter position in this case alleged, and the dependency court found that the shelter was appropriate based on evidence of abuse and imminent danger. This then picks up that kind of interruption. Report is, by definition, operating in good faith. However, the absence of reasonable cause does not prove liability. It merely removes the immunity that would otherwise apply as a matter of law. If the objective evidence does not support a conclusion that the doctor had reasonable cause to make the report, the doctor may nevertheless claim immunity from civil liability by showing that the report was made in good faith. Based on the facts before it had the above cited precedent, the trial court determined very easily that J. Hatch had reasonable cause to report suspected child abuse to the department hotline. Accordingly, the trial court found that J. Hatch was entitled to Section 39203, immunity from any civil claim which might otherwise result by reason of the reports. But the court said nothing of immunity for claims resulting from participation in a good faith in any act or authorized required by Chapter 39.
Okay, so So that's kind of the crux. So a difference of opinion between these two courts on, of course, reporting was they're immune from reporting. They had a good faith basis to report that they thought there might be some kind of abuse here. But Judge Carroll said what you did, the other things that you did that were not necessary for that, you're not immune from those actions, like the touching and the words and the pictures and the way that they treated her and spoke about her, right? But this court says, well, the court, meaning Judge Carroll, said nothing of immunity for claims resulting from, quote, participation in good faith in any act authorized or required by Chapter 39. So how broad are we really making the participation in good faith in acts authorized or required by 39? And who is going to parse out which acts should be covered and which ones should not? This appellate court thinks absolutely not a jury, because the defense was able to make those arguments that all of this during the trial, Jay Hatch was able to make the arguments that all of this was connected to the dependency and protecting children. And we want to protect children, and it's so important. This to me sounds like a fact question. What is or is not necessary? But this appellate court is taking it out of the hands of the jury, and they are determining that all these things that Miss Beatty did and that Jay Hatch did basically was all in furtherance, and they were either required or authorized by Chapter 39.
The facts of this case are unusual in that the reporter, for purposes of sections 39201 and 39203, remained a participant in Maya's care beyond the initial shelter hearing, and was required to comply with the dependency court orders by virtue of the department designating Maya's placement with Jay Hatch.
Okay, let me read this footnote. Sure. The trial court expressed trepidation in applying the Urquhart analysis insofar as Urquhart concluded that the immunity that is afforded to a medical doctor is not the same as afforded to an ordinary citizen. And then they have a cite where neither Section 39201 nor Section 39203 differentiate between doctors and ordinary citizens, except that the former are required to give their names when making a report, while the latter may remain anonymous. While we might agree with the trial court on that narrow issue, application of the statutory immunity as between doctors and ordinary citizens is not before us. So they're not going to make that distinction, but it's very clear how broad they believe this immunity should go. To a scary amount to have the government or to have doctors who, I'm not going to say doctors don't care about kids, just like lawyers care about their clients, but I'll just tell you right now, I don't care about my clients as much as their parents care about them, right? The good parents, at least. But family members care about their family members in a different way than the government does, than lawyers do, than doctors do, than anybody else does. And so we cannot let them take this type of control over our lives. I hate that type of where I feel like this is going. And they end up dropping it afterwards and sending her back with her dad, yet giving her dad no control over that, or giving him the option to kick the mom out of the house. Because I bet they would have picked that option. Kick the mom out and let her move to another state while this is all happening and let her live with the dad, who nobody seemed to have a problem with. I mean, there's so many other things I feel like that could have happened, but we're not here to rewrite rules at this point. But to me, the slippery slope argument is going against this appellate court.
As the shelter placement, Jay Hatch was required to implement the dependency court orders. Those orders required Jay Hatch to comply with visitation guidelines set forth in the orders, as well as to manage correspondence between Maya and Mrs. Kowalski. Moreover, the orders directed...
Again, hold on. Sorry, I'm going to keep interrupting. So, sure. Again, that's perfectly fine. That they are there to manage, making sure she's sheltered, making sure there's no, her mom's not sneaking in or giving her food to poison her, or even when the court said, she can't have unsupervised phone calls. That's all perfectly fine. Did you need to do all the other stuff that was presented to the jury that the jury thought was abhorrent and horrible and you should never do to somebody in your care, let alone a 10-year-old child?
I don't know if you want to touch on this footnote that I just hit on, Ken.
Sure. The dependency court orders included directives on screening visitors through the department and who specifically would be permitted visitation. Okay? Again, they're trying to stretch this into basically all the actions are covered, and I disagree with that. And I think Judge Carroll disagreed with that as well.
Moreover, the orders directed that the court would not micromanage or countermand Jay Hatch's policies, and that absent clear and compelling reasons, Jay Hatch's staff was to be free to address the medical needs of their patients without the court. the parents or others interfering, with their professional judgment.
So
J. Hatch was
stop. So this would include your mom's in a mental institution, and I could be your mom, and hugging her and kissing her on the head, and telling her dad, asking if he should get divorced. So this includes all of that.
J. Hatch was required
Certainly
to take.
should. Sorry, I
So go
wasn't
ahead.
done with my thought. It certainly should not include all that, in my opinion. Go ahead.
J. Hatch was required to take part in the sheltering of Maya by virtue of the shelter order entered October 14th, 2016. The department sought to have Maya sheltered based on the ongoing abuse and imminent danger. The dependency court sheltered Maya, and the department was authorized to determine her placement. The department placed Maya at J. Hatch for ongoing medical treatment, including psychological evaluation and weaning off ketamine. Within the text of Chapter 39, the legislature established its intent expressly. The purposes of this chapter are to provide for the care, safety, and protection of children and to prevent the occurrence of child abuse, neglect, and abandonment. The legislature further stated in its intent that Chapter 39 be liberally interpreted and construed in conformity with its declared purposes. Courts may not extend, modify, or limit the statute's express terms or its reasonable or obvious implications because to do so would be an abrogation of legislative power.
Basically meaning, sorry,
Go ahead.
basically meaning that you can't rewrite the law as the court.
Moreover, all parts of a statute must be read together in order to achieve a consistent whole. Effect must be given to every clause of the statute and meaning given to all of its parts. Case citations. Here, the trial court erred not considering the entirety of the section 39203 in its application to the facts of this case, but beyond J. Hatch's immunity from the claims premised on or immediately resulting from the reports of suspected child abuse. And nothing in the record suggests that J. Hatch's participation in implementing the dependency court orders as it was required to do was not done in good faith.
So
Although
pause there. So again, they're saying nothing in the record suggests that J. Hatch's participation in implementing the dependency court orders, those are the actions J. Hatch took to quote unquote protect Maya. None of that was done in bad faith. They did not find any record evidence of that.
Although the process was unfortunately slow and painful for the Dohertys, nothing reveals that the investigation.
Sorry, it's important for us to say we're going to hear different names. You're reading right now a case citation from Doherty, so that's why they're talking about Doherty's and they're applying this case to this to Maya's case.
Although the process was unfortunately slow and painful for the Dohertys, nothing reveals that the investigation was not instituted and conducted in good faith after a legitimate report of abuse. As such, the department, as an institution participating in good faith in acts authorized or required, was immune from civil liability, which might otherwise result by reason of its action.
And then another case, they're going to start citing Pope, so you can go into that citation.
The state argues correctly that Pope could have and should have done more, but the legislature did not condition immunity on doing more than seeking medical assistance in good faith. The legislature could have imposed more conditions. The statutory scheme at issue is intended to protect those who might be overzealous in protecting children from potential abuse.
Yeah, I agree.
This is not to suggest that this section 39203 provides absolute immunity. It provides immunity.
Feels like, though, right? Doesn't it feel like absolute immunity at this point?
That was a question that was definitely a question that was like kind of in the back of my mind as I was thinking about this. Like, at what point, where is a line that you can draw and say this crosses the line?
Exactly. And if not in this case, and by the way, usually when you have a question like that, do you know how our system is set up and who answers that question? A jury. A jury usually answers the question of what was too far, what was not done to protect Maya. They made these arguments to the jury that we were doing this to help Maya and protect Maya, which the jury basically called BS on. That's how this case ended. They were able to make these arguments. Now, again, with the self-harm of Maya's mom and some other things, I can understand why this court would want to throw that out and not allow that in, and you know how some differences would happen there, or even if they say Section 39 immunity maybe should have gone further than it did. But to act like a jury was not considering whether or not this was done for Maya's good is just not how it went. It's not how it went.
This is not to suggest that Section 39203 provides absolute immunity. It provides immunity from liability that might otherwise result from good faith reporting or good faith participation in acts authorized or required by Chapter 39. Florida statutes protect against liability for carrying out the protective measures of Chapter 827 on behalf of the protected case. It does not protect against failing to carry out the protective measures. There are complexities created by the interplay of Chapter 39 with the claims raised in this case. We are aided in interpreting and applying Chapter 39 by the amicus curiae briefs filed by the American Academy of Pediatrics, the Children's Hospital Association, and the Florida Hospital Association. The Florida Hospital Association, FHA, articulated its concerns with the trial court's ruling in this case.
All right, pause. So look at all these hospital associations jumping in to help. Why do you think that's happening? And again, that's what I mentioned in the beginning. It's like these huge organizations and lobbyist group, and plaintiffs' lawyers have it too. Plaintiffs' lawyers have lobbyist groups, and we're trying to affect the law as well. Everybody's trying to affect the law for what they think is fair and what they think is just. It's pennies on the dollar when it's compared to insurance companies, hospitals, these big corporations all combining together, and they get their way in the law. And there's plenty of people on all sides of political aisles and lobbyist aisles that I agree with and disagree with. But you're getting to see an illustration of what it looks like when the hospital gets to write these rules, or we have the free kill bill in Florida, where basically if you're of a certain age and you don't have dependents, a doctor can get drunk and get behind the wheel of the car and hit you and you can sue them, but they can get drunk and come commit medical malpractice and you can't sue them. So there are all these laws put in place that doctors and hospitals and insurance companies fight for. And then again, you can tell me on the other side that there are lawyers you hate that they fight for certain laws, fine, but you're seeing an illustration of how something can go so far and really affect somebody's life. And this is going to create huge precedent going forward on, you really want to come sue the hospital for something they did? Good luck.
The trial court found, as a matter of law, that J. Hatch had a reasonable basis for suspecting that their patient was the subject of child abuse. The J. Hatch acted in good faith in reporting that suspicion, and the J. Hatch could not be held liable for any cause of action directly arising from sheltering the child pursuant to a court order.
Pause. So pause there. J. Hatch could not be held liable for any cause of action directly arising. Again, they're using these words. What actions are directly arising? I think that should be a jury question. Did Miss Beatty have to do everything she did? Did Dr. Smith have to do everything she did? And again, we'll talk about whether or not Dr. Smith is an agent. But to me, that's the issue. It's just like, that's absolute immunity once you make the report. Anything you do after, absolute immunity.
Unfortunately, these findings were rendered meaningless at the trial itself when the court permitted the Kowalskis to attack J. Hatch's basis for suspecting abuse, its motives for reporting that suspicion, and present evidence to the jury of the psychological impact of the court-ordered sheltering period. The actions of J. Hatch with respect to their good faith mandatory reporting were repeatedly called into question and leveraged by the Kowalskis in their effort to secure a finding of civil liability and an award for damages.
So another pause. I am hoping that at the end of this, we're going to talk about what do the Kowalskis have left? What can they do now? I am hoping that the way Judge Carroll reads this is that they can't say, they should have never mandatorily reported, fine, but that they can still complain about all of the actions J. Hatch actually took in implementing this Rule 39 as not being done in good faith. I think they should be able to argue that to the jury.
The trial court found that Section 39203 immunity flows for any civil liability that may result by reason of the child abuse report, and that without question, an investigation, shelter, removal of custody, and prohibiting visitation are all are outcomes that logically could occur from a report to the abuse hotline. The trial court implicitly recognized that the dependency court orders that is, those sheltering a child and restricting or prohibiting visitation may result from the reporting and investigation of abuse. Yet the trial court failed to give effect to its interpretation by permitting the jury to hear significant and inflammatory testimony concerning the restrictions put in place by the dependency court and the impacts of those restrictions on the Kowalskis.
All right, stop again. There's a difference between saying your mom can't come and saying your mom's in a mental institution. I could be your mom. Dad, you should get a divorce. There's a difference in how they shelter and how they cut off communication and how they handle and speak to Maya in those scenarios. So it's like, oh, they talked about this inflammatory testimony concerning these restrictions. Well, maybe the way they imposed those restrictions were wrong and not done in good faith.
For example, Mr. Kowalski testified that Mrs. Kowalski lost consciousness and fell to the floor upon learning that she was not going to be able to see Maya, and that during the time she was unable to see Maya, Mrs. Kowalski deteriorated. She was losing hope. He reportedly testified to the profound impacts of the dependency court orders on Mrs. Kowalski. Maya also testified to the impacts of the dependency court orders on her, from anger and not being able to speak with or see her mother to feelings of isolation. Maya testified that she was suspicious about the comments made to her and the restrictions placed on her. No one ever directly told her what was going on, and she had to figure out for herself that she was being stripped from her family. She testified that JHatch provided her with a My Care journal, and that in it she listed names of JHatch doctors and nurses with notations and drawings. I was trying to think to get out of the hospital, and I'm 10. So I'm thinking if they think I like you, then I'll get out.
All right, pause. So I do agree with some of this by the court. I do agree that, the Beata Kowalski stuff potentially was letting them go too far about how it affected her, the fact that they were cut off, and making a lot of those arguments that because of a legitimate report and the court decided to make them shelter, that there was probably too much testimony. But again, where are those lines and what could this appellate court done different than what they ended up doing? But that potentially they did allow too much argument in effect to make the hospital look like the bad guy because the dependency court said she had to be cut off for her family. I think there is some nuance there, and I agree with some of what the court is saying, that to then hold that and make the jury hate the hospital for doing what the court ordered them to do, they should be immune from that. So I do agree with that, and I understand where they're coming from here, and I'm trying to be fair. I'm trying to see it both ways, but there's no way you can wipe out everything the hospital did. But at the same time, we can't make the jury hate the hospital for doing what the court ordered them to do, which means not allow her mom to come, supervise calls, things like that, to let the jury hear how much that hurt a family is not appropriate, because that hurts every family that this happens to. And yet we still know that we do that to try and protect kids. So there's got to be a balance. And I get where the court is coming from, that they don't think this court, Judge Carroll, struck the appropriate balance.
We kind of ended off on a really good footnote here if you want to.
Okay.
Look at that for a second.
The closing arguments were also inflammatory. Counsel for the Kowalskis argued that JHatch took Miss Kowalski out of the game by changing its diagnosis and treating the Kowalskis like criminals. Counsel then went through JHatch's defenses, because if we get rid of the defenses, then all that is left is the Kowalskis case. Counsel for the Kowalskis argued that something happened between Miss Kowalski and JHatch that ticked JHatch off, causing JHatch to call the department, and that JHatch was not going to let this brusque lady with an Eastern European accent come in and tell them how to do their job. They argued that JHatch calling the department hotline was retaliatory against Mrs. Kowalski, and that she committed self-harm because she knew that if she did not take drastic action, Maya would end up in some kind of foster care or die. So again, this is, once you get the judge's ruling, this is the plaintiff's attorney running all the way down that line. And you can get in trouble if you do that, if it ends up getting overturned, which leads me to, so first off, I agree. There are issues with that, obviously, based on what this court is ruling on the Beata Kowalski claims. We always knew that was an issue, but usually once you get a $200 million verdict, by the way, in case anybody doesn't know, a lot of these verdicts you see on billboards or websites, $10 million verdict, $50 million verdict, $200 million verdict, almost never is that what people get paid. There's always some kind of settlement after the fact. We talked about this. Usually when you go get a $200 million verdict, and I'll just take a second, we're an hour into the video, I might as well pause and give kind of a big picture look at this. Usually when you get a $200 million verdict, you're able to settle the case for something less than that, and it's life-changing money for Maya Kowalski, and it's what she deserves for what she went through, and we get this case done, it's over, and it's behind us, and we don't have to worry about this appeal, okay? But when you have the infighting in attorneys, and you have funding loans for some of the fees, and the lawyers fighting about who got what fees, that does not help Maya. That was my number one focus when I saw all of those problems is how is this hurting Maya? How are they able to negotiate a settlement? And some people are like, oh, they should never settle. You should always settle if it's a fair number. And you get rid of the risk of an appeal because this was always a real risk. I think that this was surprising to the plaintiffs. I don't think this was jaw-dropping, fall out of your chair, shocking that they got rid of some of these claims and overturned at least some of the self-harm claims with Beata. I think you're not being honest with yourself as a lawyer if you're saying you were absolutely floored or shocked that that happened. Okay? So how does all of the infighting with the plaintiff's attorneys affect Maya here? It's not good. And I heard rumblings. I don't know if it's true or not. Okay. This is completely like just being a lawyer in Florida and hearing people talk about some of these big cases. I heard rumblings that there were some legitimate offers made by J Hatch. That could be completely false. I don't know, but that the plaintiffs did not accept it. Now, why didn't they? I don't know. What are legitimate offers? Everybody will have different opinions. I have defense attorneys tell me they make legitimate offers all the time that I don't think are legitimate. I think I make legitimate compromises that they don't think are legitimate, and that's fine. But looking at it now, it's tough to stomach. It's really, really tough to stomach. And again, once you get the rulings your way, I understand going full bore. And these types of portions of the closing argument are why they got $200 million. But it's also a reason why the entire thing gets flipped on its head. That's just the realistic nature of the legal system, appeals, trials, juries, appellate courts. This is the reality of how it can look. And it feels really tough to think about, how this all affects the Kowalski family.
The trial court erred by not giving effect to the portion of the statute to which it assigned meaning, and it further erred by not giving meaning to all words within the statute. Courts must give significance and effect to every word and phrase in a statute. Section 39203 provides immunity from civil liability, which might otherwise result by reason of both reporting in good faith any instance of child abuse and participating in good faith in any act authorized or required by Chapter 39. 91 of Maya's 97 days in J Hatch were the result of dependency court orders wherein the department had been given placement and care responsibility of Maya while she remained under protective supervision. J Hatch argues that the trial court's errors in interpreting and applying Section 39203 immunity should result in a new trial for all claims. We agree that the trial court's ruling on Section 39203 immunity permeated the entire trial. A new trial is required on all counts not otherwise disposed by this opinion.
All right, pause. So this is the reason why. They're about to just kick out claims that Maya went to trial on and won, and a jury gave her a lot of money. They're about to say, you can't even retry those. We're throwing those out completely. And we're going to hear about some of those. But every claim they don't throw out, now you have to go back and retry every single one of these. And guess what? You can't use anything required, directed, or somewhat connected to the report to the hotline. And how Judge Carroll is going to parse that out, we still have to see what facts are allowed and what aren't. They also said 91 of the 97 days. Fine. The fact that she was, sheltered for 91 days, but what did they do while she was sheltered should absolutely be able to be part of these claims. So think about now the scenario the Kowalskis are in. They've got two lawyers fighting about who their lawyer is, who owes who what. Sanctions going both ways between her own lawyers, between the defense lawyers and the plaintiff's lawyers. We've got all sorts of issues there. And now I told you from the jump that these plaintiff's lawyers deserve a lot of credit because I don't know that I would have taken this case. I think most lawyers, if they're honest with themselves, they probably would not have taken this case the first time around. It's going to be expensive. It's going to be difficult. You're going against deep pockets, as is evidenced by this entire appeal situation. Unlimited funds, basically, and experts. You're going up against Goliath, and you are David. And guess what? They threw the stone, and they knocked over, and they killed Goliath. But somebody came, lifted Goliath back up now as the appellate court, and you've got to do it all over again. But guess what? It's even harder now. It's even more expensive now. And your claims are gutted. First off, half your claims are going to get thrown out. And the half that remain are completely gutted with the facts that you feel are necessary to prove them. So it's going to be, I don't know if either of these lawyers or both of these lawyers or one of these lawyers or some other lawyer is going to come on and take this case. Maybe somebody nationally is watching this, is going to come take on this case. This is an extremely difficult case, and it is 10 times harder now than it was before. And it was hard before. It was hard before. I know $200 million sounds great to everybody in the world, a lot of money, plaintiff's lawyers salivating for a $200 million verdict. Fine. It was hard. This was not easy to get $200 million on, and now it's going to be way more difficult. I cannot emphasize that enough. Let's talk about the false imprisonment claim now.
False imprisonment, October 7th through 13th, 2016. The trial court denied J. Hatch's motion for directed verdict as to the false imprisonment claim for J. Hatch's actions between October 7th and October 13th, 2016. This was error. The essential elements of
Error
cause.
meaning the judge should have thrown this claim out, granted directed verdict, and thrown this claim out. A jury should have never heard it. Go ahead.
The essential elements of a cause of action for false imprisonment include the unlawful detention and deprivation of a liberty of a person against that person's will without legal authority or color of authority, and which is unreasonable and unwarranted under the circumstances. All elements must be proven for a plaintiff to recover on a false imprisonment claim. The October 7th through October 13th allegations stem from J. Hatch's refusal to release Maya from the ER and PICU. J. Hatch argues both that it had legal authority and that there was no evidence that keeping Maya in its care was unreasonable or unwarranted under the circumstances, whether because of Maya's pain levels and overall health at the time or because of the suspected child abuse. We need only consider whether the hospital was without legal authority or color of authority, a question of law to resolve this issue. Whether the Florida Public Service Commission has the authority to act is a question of law, which is subject to de novo review. J. Hatch's legal authority or color of authority stems from Section 39395. Any person in charge of a hospital or similar institution, or any physician or licensed healthcare professional treating a child may detain that child without the consent of the parents, caregiver, or legal custodian, whether or not additional medical treatment is required. If the circumstances are such, or if the condition of the child is such that returning the child to the care or custody of the parents, caregiver, or legal custodian presents an imminent danger to the child's life or physical or mental health. Emphasis added, we are mindful that Section 39395 also requires that any such person detaining a child shall immediately notify the department, and that the department shall immediately begin a child protective investigation in accordance with the provision of this chapter. Beyond the initial detention and reporting of the department, the legislature has placed no burden on the person detaining the child. Instead, it has placed the burden on the department. If the department determines, according to the criteria set forth in this chapter, that the child should be detained longer than 24 hours, it shall petition the court through the attorney representing the Department of Children and Families as quickly as possible and not to exceed 24 hours for an order authorizing such custody in the same manner as if the child were placed in a shelter. Certainly, Section 39395 provides color of authority for J. Hatch's detention of Maya in the ER and PICU during the period between the first and second reports of the department and following the second report. On October 9th, 2016, the department instituted its investigation. Moreover, J. Hatch's actions were authorized or required by Chapter 39, and there is no evidence that its participation was not in good faith, particularly where the trial court concluded as a matter of law that J. Hatch had reasonable cause to suspect child abuse. As such, J. Hatch is immune from liability resulting from its detention of Maya between October 7th and October 13th, 2016. Accordingly, J. Hatch's motion for directed verdict on the claim of false imprisonment for the period of October 7th through October 13th, 2016 should have been granted.
All right. So basically they're saying they had legal authority to do it. So therefore that's one of the elements, should have been thrown out. Simple as that. Gone. Damages gone, claim gone, you cannot retry it, you don't pass go, you don't collect $200, it's over. The next one is going to deal with Beata Kowalski's self-harm now, and this is a big one, and this is one where probably I will have the most agreement with the appellate court.
Intentional infliction of emotional distress, Beata Kowalski. Two claims of intentional infliction of emotional distress specific to Beata Kowalski were resolved by the jury in favor of the Kowalskis after the trial court denied J. Hatch's motions for directed verdicts. J. Hatch contends that its motions for directed verdicts should have been granted because the Kowalskis failed to present evidence of evidence of conduct directed at Mrs. Kowalski and the Kowalskis' evidence was insufficient as a matter of law. We agree. To support a claim for IIED, a plaintiff must prove the wrongdoer's conduct was intentional or reckless. That is, he intended his behavior when we knew or should have known that emotional distress would likely result. The conduct was outrageous, that is, as to go beyond all bounds of decency and to be regarded as odious and utterly intolerable in a civilized community. The conduct caused emotional distress, and the emotional distress was severe. The trial court must make the initial determination on a second motion for directed verdict that the evidence presented meets that high standard. Pleading a cause of action for the intentional infliction of emotional distress is one thing. Avoiding summary judgment or prevailing at a trial is quite another. And because the outrageousness test is objective, the testimony as to the plaintiff's beliefs on whether the defendant intended to cause emotional distress is of no moment. Likewise, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. As relevant to the estate's IIED claims, in order to state a claim for IIED based on one's own emotional distress, a plaintiff must be present when the alleged extreme and outrageous conducted its directed toward a third party. Appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Otherwise, the conduct alleged to be outrageous must be directed at the plaintiff.
Meaning, so basically what they're saying is the outrageous conduct either needs to be towards you, or you need to see it and experience it being directed towards a third party for it to affect you.
Appellant's claim for intentional infliction of emotional distress fails because there was no showing of outrageous conduct directed at appellant herself. In all cases, we have found in Florida, recognizing the tort of intentional infliction of emotional distress, the plaintiff was the recipient of the insult or abuse, or the message was clearly directed at the plaintiff through a third person. Emphasis added. Stated differently, if the plaintiff is not present to witness the outrageous conduct, the plaintiff must have been the target of the outrageous conduct. Different citations. The Kowalskis presented no evidence that Mrs. Kowalski was the target of any of the conduct alleged to be outrageous. Rather, the heart of the Kowalskis' claim, repeated in various ways throughout multiple bench conferences and asserted before the jury, was that the separation of mother from child with knowledge by both and without the ability to combat it was outrageous. The Kowalskis
And again, this goes through that Rule 39. They had to separate them, and using the separation to explain all of this is a problem. Also, the fact that they're going to throw out this claim, I would gather, means they're not going to be able to mention what happened to Beata Kowalski, not how it affected Maya, going to have nothing to do with the damages. Just think about how that affects the value of this case and the way it's presented to a jury. Completely changes the game.
The Kowalskis argued a plan that is told to the mother that we're going to take away your child and there's nothing you can do about it. The real outrageousness is the systematic nature of the actions against Mrs. Kowalski through this. And every contact that she had and everything she learned reinforced that there was a plan to take her daughter away, and that is outrageous in our society.
So hold on. So there's also a scenario where the way they separate matters, and that's where the nuance is being lost here. Because I really think the way you separate parent and child should lead to some kind of civil cause of action if you do it in an extremely horrible way that damages both of them. There's a right way to do things, there's a wrong way to do things, even legally.
The Kowalskis contended that there were concerted efforts to raise the pressure on Mrs. Kowalski. If this doesn't get her, let's suggest that Mr. Kowalski get a divorce. And if this doesn't get her, let's tell Maya that I'm going to be her mother. The Kowalskis acknowledged that these statements were not made directly to Mrs. Kowalski because she wasn't allowed in the hospital, but were funneled to her through a proxy, which was her child or her husband. That Mr. Kowalski or Maya relayed that they had seen or experienced is not evidence that J. Hatch's actions were directed to Mrs. Kowalski. And there was no evidence that Mrs. Kowalski was somehow the target of statements made to either Maya or Mr. Kowalski. Moreover, the trial court recognized that the allegations in the operative complaint were insufficient when it granted J. Hatch's pretrial motion to dismiss the IIED claims as to Mr. Kowalski, with the exception of actions immune under Section 39203 and the assertion that Mrs. Kowalski suffered from Munchausen syndrome by proxy. There is little difference between the allegations the trial court found legally sufficient as to Mr. Kowalski's claim and the evidence presented as to the estate's claims. The Kowalski's evidence was legally insufficient to survive directed verdict. The motions for directed verdicts on the IIED claims specific to Mrs. Kowalski should have been granted.
All right, so pause there. So basically they're saying the judge booted Mr. Kowalski's claims, but not Mrs., and they were basically the same, so he should have booted Mrs. as well. Okay, that's basically what they're saying. I get it. I understand. This is the one I can probably understand the most as to why the appellate court ruled this way. I'll give you a break. I'll read the next one, and then you can jump back in. So the intentional infliction of emotional distress now from Maya Kowalski, which is one of the claims that is going to survive. They're not going to throw it out, but she does have to completely retry it. In denying J. Hatch's motion for a directed verdict specific to Maya Kowalski's claim, the trial court considered evidence for which J. Hatch should have been immune from liability and evidence of other pleaded torts. This was error. So they're not throwing it out, but they are giving a new trial, and they're basically telling the court, you have screwed up because you allowed them to argue evidence that should have never come in. You're going to have to scroll here because I'm looking at it on my own screen. We reiterate that the actions for which J. Hatch should have been immune pursuant to Section 39 cannot be used to establish liability. The department placed Maya with J. Hatch. J. Hatch's participation, quote unquote, in the Chapter 39 proceedings, as well as its initial reports of suspected child abuse to the department, pervaded the Kowalski's evidence of intentional infliction of emotional distress against Maya. The trial court was required to consider which of J. Hatch's actions should have been immune from liability and which actions could support the independently pleaded tort of IIED. Medical professionals' disagreements about a complex medical case and perhaps overzealous implementation of dependency court orders are not acts that are intolerable in a civilized community. The rendering of substandard medical care does not constitute the intentional infliction of emotional distress. So just because they did bad medical care, you can't be sued for IIED. Good faith actions. And it seems like this appellate court feels like everything J. Hatch did was in good faith. I don't know why they're making that decision. That seems like a factual decision to me. Good faith actions to protect children are neither utterly tolerable in a civilized community nor beyond all possible bounds of decency. Indeed, Section 39 immunity protects those who might be overzealous in protecting children from potential abuse. To the extent J. Hatch took action within its legal rights under Chapter 39 or otherwise, it cannot be liable for IIED. A privilege exists as a matter of law to engage in reckless or even outrageous conduct if there is sufficient evidence that shows the defendant did no more than assert legal rights in a legally permissible way. Well, how about that? A privilege exists as a matter of law to engage in reckless or even outrageous conduct if there is sufficient evidence that shows the defendant did no more than assert legal rights in a legally permissible way. So is that what they did? Did J. Hatch do no more than assert their legal rights in this case? You tell me what you think in the comments. Additionally, IIED conduct must not be violative of any other recognized tort. That is, the facts upon which it is based must be independent of any other alleged tort. Because the actions of the chargeable defendants can be deemed to fit within the false imprisonment category, those actions will not support a claim of IIED. Obviously, if the sole basis of a complaint for emotional distress is a privileged defamatory statement, then no separate cause of action exists. So basically they're saying don't tack on IIED onto all your other claims, which again, we saw this kind of argued in Karen Reed's case, and the judge decided the other way. A plaintiff cannot transform a defamation action into a claim for IIED simply because characterizing the alleged defamatory statements as outrageous. Where the conduct alleged to be outrageous is itself a pleaded tort, a claim of IIED cannot lie. By the way, Wait till we hear the concurring opinion. It's going to focus on this claim. Here, the Kowalskis relied upon evidence of other pleaded torts in order to establish the IIED claim. The law is clear, however, that the evidence supporting Maya's 3 false imprisonment claims, as well as her battery claims and medical negligence claims, cannot also be used to meet the legal threshold for IIED. So basically, he's saying whatever claims exist, you can't double up with an IIED. And that's going to be a decision they're going to have to make. I'm going to read this footnote, and then, John, you're going to jump back in for the medical negligence.
Cool.
Further, evidence supporting that negligent hiring and supervision claim cannot be used. That claim was resolved in favor of JHatch. And while the Kowalskis argued that the evidence taken as a whole indicates that there was a desire and plan on the part of Miss Beatty to separate Maya from Miss Kowalski, and that there was a plan by the hospital to force Miss Kowalski and Maya and Mr. Kowalski to change their story to the extent that such evidence is not subject to Section 39 immunity. There is also no evidence of any such concerted effort. See, and that's what I'm saying. They're entering the province of the jury to say there's no evidence of any such concerted effort. I think some jurors might disagree with that. Then they cite a case that says, concluding that the plaintiff's testimony as to her beliefs on whether the defendant intended to hurt her was of no moment. The subjective response to the person who is the target of the actor's conduct is not to control the question of whether the tort of IIED occurred. Moreover, the trial court granted summary judgment in favor of JHatch on the Kowalski's conspiracy claim pre-trial.
Medical negligence, apparent agency. JHatch contends that the trial court erred in denying its motion for the directed verdict on the narrow issue of apparent agency as it relates to Dr. Smith, and that Chapter 39 otherwise immunizes Dr. Smith's actions such that JHatch cannot be held liable for these actions. We agree. An apparent agency exists only if all 3 of the following elements are present: a representation by the purported principal, a reliance on that representation by a third party, and a change in position by the third party in reliance on the representation.
So basically, the appellate court is saying we don't find that Dr. Smith was an agent of JHatch, and they're going to explain why.
Mr. Kowalski testified that he was unaware that Dr. Smith was not a JHatch doctor at the time he first met her, but that he could not specify the date. He testified that she was wearing a white lab coat when she came into Maya's room and started asking questions. Maya testified that she was unaware of who Dr. Smith was or in what capacity she questioned Maya's father. An email dated October 12th, 2016 from Mrs. Kowalski's email address was entered into evidence. In the email, Mrs. Kowalski reported that on October 11th, 2016, she and Dr. Sally Smith, who was sent by the department to investigate the possible child abuse neglect, had a second visit at which Mrs. Kowalski described Maya's illness and the doctors involved in Maya's care. Thus, no later than October 11th, 2016, Mrs. Kowalski was aware that Dr. Smith was acting in her capacity as a child protective team CPT physician. And certainly by the October 14th sheltering hearing, Mr. Kowalski was also aware. The Kowalskis presented no evidence.
So this is the appellate court saying we don't necessarily believe Mr. Kowalski that he thought she was part of JHatch. And instead, because there's record evidence that somebody else said, Dr. Smith said she's not with JHatch, that is the only fact the jury could have found, is what it feels like to me. That's what it feels like to me when I hear this.
The Kowalskis presented no evidence that they materially changed their position prior to October 11th or October 14th on the basis of Dr. Smith being an apparent agent of JHatch. Rather, the Kowalskis acknowledged that they were unaware that JHatch had given Dr. Smith full access to Maya's medical records at the time such access was provided. The apparent agency
to me, them looking at it and finding facts completely different than the jury did. That's. I think if the jury read the way this appellate court wrote things that they found to be factually true in this case, I don't think the jury would have seen it the same way. I feel confident about that, and that's not how it should be.
The apparent agency theory should have been rejected as a matter of law by the trial court, and a directed verdict as to that specific claim should have been granted. Nonetheless, even were Dr. Smith an apparent agent of the hospital, because Dr. Smith was the CPT medical director, she was authorized by Chapter 39 to take the actions that she took. Her actions would not subject JHatch to liability unless JHatch was not participating in good faith in acts authorized by Chapter 39. It was the Kowalski's burden to prove either that J. Hatch was not participating in good faith in authorized or required acts, or that Dr. Smith was not acting in her capacity as the CPT medical director. In admitting evidence of the Dr. Smith's actions without proper consideration of the statutory immunity, the trial court relieved Kowalski's of their burden.
So basically, Dr. Smith's actions, even if she was an agent, are all covered under Chapter 39.
Punitive damages.
And
Sorry.
hold on. And J. Hatch was participating in good faith. And therefore, it's all good. I mean, that's the stuff I think is just crazy. The view that this court took is just so clearly they feel like, everything the hospital did was fine and they shouldn't have, they shouldn't have this big verdict against it. That's what it feels like as I read this. It really is. It feels like a different view of the facts as opposed to the application of the law. And that's tough. That's tough. It's tough to read, I'm sure, for the Kowalskis. Now, I do agree. I think this was a case that, depending on who the trial court was, it could have gone a million different directions. Same thing with who the appeals court was, right? It could have gone in a million different directions. So I don't necessarily have any beef with them disagreeing with some of the rulings and the way they look at the law, disagreeing with how Judge Carroll handled some of this. But it's really the way they recite some of the facts that make me feel uneasy.
Punitive damages. J. Hatch contends that the trial court erred in denying its motion for the directed verdict on the issue of punitive damages as to the false imprisonment and battery claims. In all civil actions, the plaintiff must establish at trial, by clear and convincing evidence, its entitlement to an award of punitive damages. And a defendant may be held liable for punitive damages only if the trier of fact, based on clear and convincing evidence, finds that the defendant was personally guilty of intentional misconduct or gross negligence. Clear and convincing evidence, an intermediate burden of proof, requires that the evidence must be found to be credible, the facts to which the witness testify must be distinctly remembered, the testimony must be precise and explicit, and the witness must be lacking in confusion as to the facts in the issue. The evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction without hesitancy as to the truth of the allegations sought to be established.
So they also say this footnote is, although our reversal on this judgment on the false imprisonment makes this moot, if we were to have to decide it, we would have said the judge should have granted the directed verdict and they shouldn't have been allowed to go against get punitive damages because it's not intentional misconduct or gross negligence. So if you were going to allow somebody to say you falsely imprisoned me for no legal reason, it's like, no, that wasn't intentional or grossly negligent.
In the case of an employer, principal, corporation, or other legal entity, punitive damages may be imposed for the conduct of an employee or agent only if the conduct of the employee or agent constitutes intentional misconduct or gross negligence, and the employer, principal, corporation, or other legal entity actively and knowingly participated in such conduct. The officers, directors, or managers of the employer's, principal, corporation, or other legal entity knowingly condoned, ratified, or consented to such conduct, or the employer, principal, corporation, or other legal entity engaged in conduct that constituted gross negligence and that contributed to the loss, damages, or injury suffered by the claimant. Intentional misconduct is defined as a defendant having actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursuing that course of conduct, resulting in injury or damage. Gross negligence is defined as conduct so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. As to the January 6th battery and false imprisonment claims, Ms. Beatty testified that she was told to take photographs of Maya before Maya could leave the hospital for the dependency court hearing. The Kowalskis presented evidence that a risk management analysis within the risk management department of J. Hatch directed the actions on January 6th. Evidence established that it was J. Hatch's policy that the risk management department reports to senior counsel, and then senior counsel reports to the president of J. Hatch.
So this is, this is giving vibes of, as long as you don't know what your employees are doing, you're all good. And how can we separate all of this? And basically, they're saying, because we talked about this before in Florida, that in Florida you can't just plead punitive damages. You have to go later and ask the court, do I have a case that I can plead punitive damages on? Let me prove it to you by clear and convincing evidence. And the court makes a decision, yes. Then you file a new complaint, an amended complaint with punitive damages. So you have to clear a bar to even get there. Only certain cases get there because punitive damages are such a big deal. And this court's basically saying, they didn't clear that bar.
Few cases cited here, one which references noting that a mid-level employee had a manager of his own to whom he reported. Another, construction managers, superintendents, and construction workers were not on the record before us, officers or managing members of the limited liability companies. There was no clear and convincing evidence that J. Hatch actively and knowingly participated in or engaged in intentional misconduct or gross negligence. A citation here: a managing agent is an individual like a president or primary owner who holds a position with the corporation which might result in his acts being deemed the acts of the corporation. Second alteration in original. Some cases referenced to which plaintiff failed to present evidence establishing the defendant's employees held positions as corporate policymakers, which might result in conduct deemed to be the defendant corporation's acts. Cases referenced. Another one.
I don't remember how this came out in trial, but I remember they did argue about this. Let's keep going. I'm losing steam here.
Likewise, there was no clear and convincing evidence that the actions in question in this case were related to senior counsel or to the CEO, much less that anyone ratified or condoned the actions other than the risk management analysis. Before one may infer that a principal ratified an unauthorized act of this agent, the evidence must demonstrate that the principal was fully informed beyond having simple constructive knowledge, and that he approved of the act.
I mean, think about how much protection there is for companies here, right? Like how many hoops you have to jump through to prove this person doesn't just like have heard it in the hallways, but they can't be held liable for these things their employees do, even if it's furthering their interests or making them money.
And there was no evidence that a risk management analysis satisfies the statutory requirement of officer, director, or manager of employees. Finally, to the extent that the Kowalskis argued ratification after the fact, actions taken after the happening of a tortuous act are not admissible on the issue of punitive damages, nor can those subsequent actions from the basis for bringing such a damage claim. In the absence of clear and convincing evidence, the issue of punitive damages should not have gone to jury. As to the October 18th...
Meaning they should not have even had the arguments about how much money are we going to use to punish them. So it's, again, a huge chunk of the verdict, a huge leverage point for the plaintiff, gone. Big money, gone.
As to the October 18th through October 20th false imprisonment claim, there was no evidence that the physicians involved in moving Maya to the EEG room had actual knowledge of the wrongfulness of the conduct, or that moving Maya into the room with video monitoring was reckless or wanting in care. Further, like the claims of the January 6th false imprisonment and battery, there was no evidence presented that J. Hatch participated in the actions or that the officers, directors, or managers of J. Hatch condoned or ratified the conduct. Case referenced here.
It's showing how much this protects companies, right? That all your employees who are doctors and nurses and intelligent people with real jobs making real money, it's like, nope, what they do can't be held against J. Hatch for punitive damages purposes.
The admission that Wool has no idea if management at any level was ever notified of the calls and emails destroys any basis to ground a claim for punitive damages against McLean Food Service. Wool makes no allegation that any managing agent of the employer was aware of customer complaints regarding the stacking of boxes at her restaurant location, let alone they endured, approved, or willfully disregarded any unreasonable risk. Another case.
And to an extent, we get that, right? We understand that, some low-level employee does something that's intentional. You can't necessarily get the corporation for punitive damages. We get that. But this is different. This is different than that, right? These are policy issues. These are big issues that had been going on for months that people were complaining about. There was other lawsuits and courts involved. Like, this is not an employee walked outside on break and punched somebody in the face, right? That's very different than what we're dealing with here.
One additional case reference pulling out, concluding there was insufficient record evidence to establish that the treating physician knew that there was a high probability that additional injury or damage would result to patient, or that treating physician, as president of hospital, condoned or ratified actions taken. The trial court erred in submitting the punitive damages claims to the jury. Next
So
section.
those are gone.
Fraudulent billing. The court denied J. Hatch's motion for directed verdict on Mr. Kowalski's claim that J. Hatch fraudulently billed the Kowalski's health insurance carrier by using a billing code for CRPS.
All right, so hold on. Let's just talk about this. So number one, we knew this one was going to lose, right? We knew it was going to lose. I think they asked for $1 or something at the end. They didn't even really prove it up. But again, it was one of those things that indicates to a higher court these inflammatory facts that were given to the jury just made them give the plaintiffs everything. It's way too much. It's unfair. We have to do something about it. This was another one that added to that. But there was a really important fact. The whole trial, you're lying about CRPS. You don't have it. It's not even a real thing. You don't need ketamine. Yet the whole time, what are they billing for treating CRPS? A very good fact that'll piss you off if you're a jury, make you hate J. Hatch. And that's why this is going to be a big deal that they're overturning and throwing out this count completely. How much is that going to limit what the Kowalskis can argue about what they did or didn't know, or did think or didn't think? What were they lying about or setting them up about CRPS? It's going to completely change the theory and the way the case is tried.
To survive directed verdict, Mr. Kowalski had to establish that J. Hatch made a false statement concerning a material fact in the bills to Mr. Kowalski and his insurance company, that J. Hatch knew the statement was false when it made it, that J. Hatch intended that Mr. Kowalski or his insurer would rely upon the false statement, and that Mr. Kowalski or his insurer was injured as a result of that reliance. Case citation here. There are 4 elements of fraudulent misrepresentation: a false statement concerning a material fact, the representer's knowledge that the representation is false, an intention the representation induce another to act on it, and consequent injury by the party acting in reliance on the representation. Generally speaking, to satisfy the element of an injury, the claimant must establish that he or she has sustained pecuniary damage or injury by which he or she has been placed in a worse position than he or she would have been absent the fraud. J. Hatch contends that the trial court erred in denying its motion for directed verdict, where Mr. Kowalski presented no evidence that J. Hatch made a false statement of material fact in billing Mr. Kowalski's insurance carrier under a code for CRPS, and he presented no evidence of damages. We agree.
I agree with that. I do agree with that. They didn't present a damages argument. It basically felt like they gave up on this claim, honestly.
There is no dispute that Maya was admitted to J. Hatch having already been diagnosed with CRPS by another physician. The dispute concerns J. Hatch's billing of the Kowalski's insurer, where, according to Mr. Kowalski, the hospital did not believe that Maya had CRPS and did not treat Maya for CRPS. Evidence of J. Hatch's billing was introduced, as was evidence of payments by the insurer. However, Mr. Kowalski presented no evidence that J. Hatch's bills included the false statements. That is, Mr. Kowalski presented no evidence that J. Hatch billed for services or treatments it did not perform, or that it billed under a diagnosis that Maya did not have. J. Hatch's bills included as many as 12 diagnosis codes, and Mr. Kowalski was unable to testify what percentage of the insurer reimbursement was for CRPS versus the other codes, including nutrition, endoscopy, and child neglect abandonment. Further, Mr. Kowalski presented no evidence that he suffered pecuniary injury for the alleged fraudulent billing. He presented no evidence that he was billed for the treatment, whether as deductible, copay, or balance payment, that was associated with CRPS diagnosis. In fact, Mr. Kowalski concedes in this appeal that no damages in the form of increased copays, premiums, or deductibles were proven at trial. Moreover, in closing argument, counsel for Mr. Kowalski suggested that the jurors award $1 in nominal damages for this claim unless they found evidence of an increase in insurance costs or copays. Post verdict, Mr. Kowalski agreed to remit the jury award to $2 because Mr. Kowalski requested damages only for deductibles or copays incurred and difficulty of finding insurance in the future. In the operative complaint, and such damages were not proven. Where the claimant is unable to prove that he or she was injured by the alleged misrepresentation, the trial court must grant a directed verdict on the claim. The trial court erred in denying J. Hatch's motion for directed verdict on this claim.
And so this is, again, this is the risk of going forward on claims, over trying the case, piling on. This is the risk of that. I understand why they did it, because there were things they could add and arguments they could make and more discovery and more things they could pile on to J. Hatch. But this one came back to bite him. And again, I'm not surprised at all at this decision by the appellate court. But there was also a way that they could just throw this out and not affect other claims. So maybe that's what the plaintiffs were thinking.
New trial. The complexities in this case are only more complicated by the existence of immunity pursuant to Section 39203. J. Hatch contends, as it did below, that the trial court's error in interpreting Section 39203 pervades not only the court's evidentiary rulings, but the trial itself, such that a new trial on all remaining counts is necessary. I don't know if you want to read that 21 bullet or footnote.
We do not address whether those claims survive on remand under a correct application of Section 39, immunity or otherwise, meaning J. Hatch could still file a motion to dismiss on some claims based on the new way that they're telling Judge Carroll to read Section 39 immunity. We would exceed our function were we to give an opinion on the merits of any of the claims for which a new trial is required. It is incumbent upon the parties to present the case anew and for the trial court to rule on the evidence and issues arising therefrom and presented to it. We decline to address events which may or may not occur at the retrial of this case. The new trial, which our action envisions, should be neither prejudiced nor watered down by their decisions, basically. We need not address every argument raised by J. Hatch on appeal in order to reverse for a new trial, and nothing in this opinion should be construed as a determination on the merits of the unreached issues. Meaning, there could have been other reasons J. Hatch was right. Other reasons J. Hatch won. We're just not going to comment on them right now because it's not necessary, because we told you the reasons they won from our perspective. Read this last part in the conclusion. Pause before we get to the concurring, because I'll make some other thoughts.
Okay. As discussed herein, we agree. Moreover, the totality of all errors and improprieties, including those not discussed herein, was pervasive enough to raise doubts as to the overall fairness of the trial court proceedings. Conclusion. The final judgment in favor of the Kowalskis is reversed. On remand, only the IIED claim brought on behalf of Maya and on the remaining false imprisonment battery and medical negligence claims may be retried. Reversed and remanded with instructions.
Okay. So basically, that's all they have left now is remaining false imprisonment, battery, medical negligence, and IIED claim for Maya. So it's not completely dead. And depending on what Judge Carroll allows them to argue, especially with the IIED and false imprisonment and battery, I still think the jury can get a decent picture, not a full picture like the last jury got, but a decent picture about what happened to Maya and how this is not appropriate. Forget about, Rule 39 or not. A lot of the actions that were taken towards Maya and what she had to go through and deal with were not appropriate. They were horrible. And the civil justice system should give Maya some justice. Now, what will happen with her attorneys and everything that I already mentioned, who the heck knows? Another question a lot of people had is, can Maya appeal this appeal? Technically, you can ask for a rehearing. You can potentially try to appeal it up to the state Supreme Court, or if there's kind of a federal question, maybe the federal United States Supreme Court. There are avenues, but they are slim to none chances, basically. This is most likely going back to the trial court level for a retrial. That is by far the most likely result here. It sucks for the Kowalskis. It's very difficult for them and everybody involved. And the longer this case goes and the more remote it is, it's harder for witnesses to remember and those types of things. We also have to remember Judge Carroll I think he still has some questions about sanctions. Is this going to affect any of his sanctions? Is he going to try to throw the plaintiffs a bone since maybe he feels like they got screwed here? It shouldn't come into account. It shouldn't affect the decisions he's going to make there. What other decisions will he make on factual basis about what Rule 39 does create immunity for and does not? I think there's still some questions Judge Carroll has to answer that may or may not be in line with what we might think the appellate court thinks now. He still has to make the decisions he thinks is right. And then as we read this concurring opinion, which is I agree, the concurring means I agree with the opinion of the court, but maybe for a different reason, or I just felt the need to write and explain my way of thinking on this, and it is eye opening. Tell me what you think Judge Smith specifically thinks from this concurring opinion. Let's read it here, John, and I'll give my opinions on what I think he's doing. And it shows that there is still meat on this bone for Maya. And maybe it was an encouragement to do not abandon this. You have not lost. All hope is not lost at this point. You still have a great argument that I agree with, and I think a jury would agree with and get behind, and it's abhorrent what happened to you. We should not just stand by and throw it all out and hope it goes away, and because the hospital does a lot of good too. It shouldn't be like that. Let's take a listen to what they say.
So this is Judge Smith specially concurring. I concur in the majority opinion, but write separately to elaborate on the discrete issue of whether J. Hatch was entitled to judgment as a matter of law on the threshold issue of outrageousness on Maya's claim for intentional infliction of emotional distress, IIED. Maya, age 10, presented to the hospital with a pain score of 10 out of 10. Ms. Beatty, a licensed clinical social worker employed by the hospital, was in charge of overseeing and making sure that J. Hatch followed the dependency court orders, including the monitoring of hospital visits and phone conversations with Maya's friends and family, including her mother. Ms. Beatty spent considerable time with Maya, overseeing her care, including her physical therapy and taking Maya to the hospital chapel. She testified that Maya was in her wheelchair 95% of the time that she saw her. She also testified that Maya told her that she was furious, angry, and in pain. She told Ms. Beatty that she can't talk to or trust anyone. Ms. Beatty was privy to emails that highlighted the hospital's concerns that Maya was self-mutilating. Maya maintained throughout her stay in the hospital that she was in debilitating pain and testified that she was worse off at the time of her discharge than when she presented to the hospital. Maya also complained that her CRPS lesions returned while she was in the hospital and were causing her pain. This is all to say that Maya was a patient in pain in a vulnerable state, not only because she was a patient dealing with debilitating pain, but also because of her tender age of 10.
So hold
From
on.
this evidence, a
So
case was
pause.
made.
Pause. Does this not seem like a very different view of the facts than the main opinion was in this case? Like, this sounds like a completely different version, a completely different way of viewing the facts, much more in line with how the jury saw things. And I think that's why this judge felt like they had to actually write a concurring opinion. Because, by the way, if you concur, you don't have to write an opinion. You can choose to, and this judge chose to for a very specific reason. And the tone is completely different, in my opinion, than the main opinion.
From this evidence, a case was made by Maya that Miss Beatty took advantage of Maya's circumstances and her vulnerable state. She lied to Maya that Maya's mother was getting a mental health treatment, telling Maya that she may have to go into medical foster care and that Miss Beatty could be her mother while she was in foster care. She further lied to Maya and used things that Maya enjoyed to encourage Maya to do better at physical therapy. But instead of rewarding her, she would stomp and leave the room saying that Maya did not do well enough.
So pause again. So this judge believes Maya and is telling it from Maya's eyes, is what it feels like. They're focusing on what Maya said as truth and as facts, which is, I think, what the appellate court should do. That's how this case came down and what the jury decided as well. Just a much more, to me, appropriate recitation of how you should look at the facts in this case.
Maya also established at trial through her own testimony that the nurses spoke loud enough for Maya to overhear that they believed that her mom was causing her symptoms. Maya testified the nurses berated her and accused her of faking her ailments. She stated that a bedside toilet was placed far from her bed so that she could not reach it without walking, which she could not do. Maya would call for help to go to the bathroom, but no one would come in and take her. So she was forced to wet or soil herself in bed or otherwise fall and injure herself. Maya testifies that the statements and actions of the nurses and Miss Beatty were done to break her down and prove and or force her to admit that she was faking her symptoms.
All right, pause again. So this judge, again, is saying, and this is what I would look at if I was the plaintiff's lawyer, all of these facts I should be able to argue in front of a jury. The faking ailments and saying her mom is trying to hurt her and saying I could be your mom and lying to Maya, all of that is not protected under Section 39. And this judge gives me the out. If the defense argues, oh no, they can't argue any of this, judge, look at the appellate court's opinion. I'll be like, judge, the concurring opinion very clearly states all these facts under Maya's IIED claim. This was absolutely, in my opinion, throwing a bone to the plaintiff's lawyers. Now, this judge clearly agrees with the rules of law that the other judges made in the main opinion. And they're saying, yeah, this should be thrown out. We do agree. We think this should be a new trial, but don't get it twisted. It doesn't mean you can't argue any of this wrongdoing applies to Maya's IIED claim. You have a lot left here to fight for. That's what this is saying to me, this concurring opinion.
Maya pleaded in her 8th amended complaint an IAED claim, alleging these behaviors caused severe emotional distress and bodily harm. The complaint specifically referenced Maya's vulnerability as a minor while she was a patient at JHatch, alleging the defendant's offenses are aggravated by the fact that Maya was a minor during the time of this outrageous conduct. The tort of IIED was first recognized by the Florida Supreme Court in Metropolitan Life Insurance v. McCarson. In Metropolitan, the court set out the 4-part test as defined by Section 46, Restatement, 2nd of Torts, 1965. First, deliberate or reckless infliction of mental suffering. Second, outrageous conduct. Third, the conduct caused the emotional distress. And fourth, the distress was severe. The distress was severe. This appeal concerns prong 2 as discussed in the initial brief and majority opinion, and so I only address this prong. Florida courts have long recognized severe emotional distress claims by vulnerable individuals under Section 46, Restatement 2nd of Torts, 1965.
And again,
Prior to Metropolitan,
you guys know we've talked a lot about this already in the Karen Reed case with this extreme emotional distress. So some of this will be repetitive, but this is specifically applying to the Maya case.
Prior to Metropolitan, the 3rd District recognized that statements to a child of tender years can cause severe emotional distress under Section 46. In Corbin, the court reversed the dismissal of a severe emotional distress claim brought under Section 46 of the Restatement of the Law of Torts, 1948 supplement, by a guardian on behalf of a 6-year-old child against the defendant. The defendant was alleged to have approached the child and said, "Do you know that your mother took a man away from his wife? Do you know God is going to punish them? Do you know that a man is sleeping in your mother's room? God will punish them."
Yeah, I mean, that's brutal, that's horrible, that's wrong. That's exactly what, needs to be protected against this. And I think this judge is saying we've got some parallels here.
The question posed by the court was whether what was said to the child was intended or reasonably calculated to cause the child severe emotional distress. The court answered that question in affirmative, holding the alleged statements and the manner and circumstances under which they were communicated to the child leave little room to doubt they were made with a purpose and intent to shame her and to shock the sensibilities of this child of tender years, relating, as they did, to the child's mother. The content and import of the statements were such that it cannot be said as a matter of law that this alleged deliberately harmful act was not one calculated to cause severe emotional distress to a child of ordinary sensibilities. Following Metropolitan, the 5th District in McAlpin v. Sokole recognized an IED claim by vulnerable patient against a healthcare provider. In McAlpin, the complaint alleged that the adult patient went to the hospital for an x-ray for her swallowing condition that caused speech difficulty and panic during attacks. Upon entering the x-ray area, the patient was verbally assaulted by a hospital physician who claimed that because the patient owed the physician's friend money, the patient would not pay the hospital bill. The physician threatened to have the patient removed from the hospital. The complaint further alleged that the actions of the physician were designed and did not take advantage of the vulnerability of the patient, submitting as she was to diagnostic tests while in fear for her health and depending for comfort and solace upon the caring and supporting atmosphere to be generated by the hospital. The trial court in McAlpin granted the physician's motion to dismiss with prejudice, finding that the physician's demand for the patient to pay the friend's bill, while albeit not a favored method, was not sufficiently outrageous to rise to the level of an IIED claim. The Fifth District disagreed, holding that the allegations of the complaint, if proved, support the patient's argument that a jury, as the trier of fact, could find that the physician's conduct was reckless and utterly outrageous in a civilized community. The physician acted in deliberate disregard of the high degree of probability that emotional distress would follow. In so holding, the district court reversed the dismissal of the IIED claim, recognizing the special relationship between a physician and a patient, and that the actions of the physician met the threshold test of extreme conduct, which would cause an average member of the community to exclaim, outrageous. This court has
So this
indeed
is
held.
this is the court giving examples of extreme and outrageous conduct, basically for they didn't have to, but they want to affirm Maya's ability for this IIED and basically encourage her. That's what this feels like to me.
This court has indeed held that the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. In Stedman, this court found instructive comment F to the section 46 of the restatement, second of torts, because it explains how knowledge of a person's particular susceptibility to emotional distress is relevant to determining whether the conduct is sufficiently extreme and outrageous to constitute intentional infliction of emotional distress. Affirming judgment for plaintiff following a bench trial where physician cursed and screamed at a patient who was known by the physician to be susceptible to emotional distress. Comment F reads, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge, where it would not be so if he did not know. It must be emphasized again, however, that major outrage is essential to the tort, and the mere fact that the actor knows that the other will regard conduct as insulting or will have his feelings hurt is not enough. Citation reference here, Stedman. The Stedman court viewed the facts of the case collectively and not in isolation, holding the actions of the insurance company, delaying the authorization of the insured's double lung transplant, was outrageous, where it was ordered by the judge of compensation claims to pay the claim, but delayed the payment, knowing that the insured would not outlive the delay and it would not have to pay.
So we could pause there. We could do a whole video on that case, right?
Yeah.
Especially with the Luigi Mangione stuff and why people are so pissed off and how do insurance companies get away with that and how hard it is to go forward on a claim like that. And originally you lose and you have to get stuff appealed and you have to win an appeal and how much money and time and energy that takes. I mean, it's literally this exists and this is what happens in the world and in the justice system. And I understand when people get incredibly frustrated. I get it.
We must acknowledge that the unequal position of the parties in a relationship where one asserts and has the power to affect the interests of the other may also supply in the heightened degree of outrageousness required for a claim of IIED. IIED claims exist where one is susceptible to emotional distress or due to the hospital's position of the parties, and this was raised by the Kowalskis in the 8th amended complaint. Specifically, the complaint asserted that Maya, age 10, was sheltered and placed in the care and custody of J Hatch. The J Hatch was charged with looking out for the best interests of Maya while in their care, and that Maya was isolated from her family, friends, schoolmates, and priest. I believe the allegations pleaded in the 8th amended complaint and as more fully developed at trial support Maya's theory of recovery for IIED under both comment F and I of section 46. Restatement second of torts. What is odious and utterly intolerable in a civilized community about the conduct here is that a licensed social worker in charge of the care of her patient should not lie and tell her patient, especially a patient of such a young age, that her mother, who has cared for her, is getting mental health treatment and will not be able to care for her in the near future, instead of consoling that child that she will be fine in foster care where that social worker can be her mother. Further, the berating by the nurses that Maya was faking her symptoms is equally odious and utterly intolerable in a civilized community, especially
I,
given
I'm I mean, aren't you so glad the judge said this? Because it's like you feel crazy reading the rest of the appellate argument where it's like, are they not seeing any of this as a problem? Like they
Mhm.
just think that it's like, well, Rule 39, sorry. It's like, and I get it. Maybe we should just change Rule 39, but thank God for this judge being like, no, you guys are all not crazy that see this as major problems as somebody with an authority position over a vulnerable 10-year-old child where their mom or dad is not there to protect them. It's crazy.
especially given Maya's physical condition and their knowing that Maya believed herself to be suffering from CRPS. Just as the patient in McAlpin went to the physician for an x ray for her medical problems and instead received verbal abuse, Maya too went to the hospital for debilitating pain and treatment, only to be broken down, mentally abused, and berated by Miss Beatty and the hospital nurses who were in a position to facilitate her care and treatment. Based upon Maya's mental health and physical condition, Miss Beatty and the nurses acted in deliberate disregard for the high degree of probability that emotional distress would follow. The common thread amongst the cases upholding the outrageousness prong is the shockingness of the statements given the unique circumstances in which those statements were made. It is my opinion the trial judge will have to weigh whether or not some of the facts that fall within the Chapter 9 immunity would be relevant and admissible on retrial as they relate to Maya's IIED claims. When considering a claim for
Hold on.
IIED,
Hold on there.
sure.
So to me, that's a little wink wink. Like, hey, listen, some of those facts might still be admissible and appropriate for this claim.
When considering a claim for IIED, the facts of that specific case must be considered. Case reference here, see Thomas v. Hospital Board of Directors of Lee County. Applying the facts of that specific case to the reverse dismissal of an IIED claim holding in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for an IIED claim. See also Williams v. City of Mineola, noting that there are times where behavior, which in other circumstances might be merely insulting, frivolous, or careless, becomes becomes indecent, outrageous, and intolerable. While I agree that some of the actions by Miss Beatty, the nurses, and other related to J Hatch are entitled to immunity under Chapter 39, and that the battery of false imprisonment and medical malpractice claims cannot be used to meet the legal threshold for Maya's IIED claim, I also agree with the argument raised by Maya in her in her brief, that Chapter 39 did not authorize or protect acts of intentional infliction or of emotional distress, especially when committed by a healthcare provider to whom vulnerable people look for care. Emphasis added. And I believe that some of the information related to Maya's shelter and the dependency court's orders would be relevant and admissible to the extent that information is required to give the jury a full picture of the circumstances at the time. It is hard to imagine a civilized community that accepts the actions of Miss Beatty, a licensed social worker, and the nurses as good faith participation in the requirements of Chapter 39. To be sure, J. Hatch makes no attempt to cast such a broad net to include these actions are privileged under Chapter 39, and in fact agreed at oral argument that the Chapter 39 immunity was not absolute. However, even after stripping Maya's IIED allegations of the offending claims and immunity entitled evidence, there remains competent substantial evidence supporting the trial court's findings that Maya's IIED claim met the high bar of outrageousness. These healthcare providers were in charge of caring for and treating Maya. Instead, they exploited their positions with full knowledge that Maya, a 10-year-old child, would not be able to endure such outrageous conduct and undoubtedly suffer severe emotional distress as a result.
So let's pause. So how about that for a little bit of an opinion there in an appellate court opinion? that she no doubt suffered severe emotional distress because they were supposed to care for her, but instead they exploited their positions. So that's number one. Then number two, when we go back up and this judge said, J. Hatch makes no attempt to cast such a broad net to include these actions as privileged under Chapter 39. In fact, they agree at oral argument that Chapter 39 immunity was not absolute. It's hard to imagine a civilized community that accepts the actions of Miss Beatty. So it's like, we all agree there's bad stuff here. So all hope is not lost. That's what I want to be a main part of this. All hope is not lost. It's bad, but it's not dead, right? That's important. And then we go down to the footnote here. J. Hatch counters some of this evidence, but weighing that the evidence against Maya's evidence is a jury question, not to be resolved on a directed verdict motion, or for that matter, in determining whether the alleged actions and statements met the threshold inquiry. In ruling on a motion for directed verdict, the trial court may not weigh the evidence or assess a witness credibility and must not deny the motion if the evidence is conflicting or if different conclusions and inferences can be drawn from it. This is big and important, this footnote 23. For everything in this case, like, are we not going to let the jury in a jury system make some decisions? This was not a bench trial. This is a jury trial. Like, come on. Let the jury make some decisions. They made plenty. All right, let's finish it up here.
The cases finding conduct outrageous are no different than the actions taken in Maya's case. In fact, Maya's case, given her vulnerable age, paired with her special relationship as a patient under the care of Miss Beatty and the nurses, is a more compelling one, which would cause an average member of our community to exclaim, outrageous. For these reasons, I agree that Maya's IIED claim should be retried with the remainder of the counts. Opinion subject to revision prior to official publication.
Yeah. So, I mean, this, from my perspective, they gave him a bunch of cases. This judge was like, hey, here's a bunch of cases. I think they're just like Maya's case. So take a look here, plaintiff's lawyers. Fight this hard. Use these facts. Judge Carroll, do not take out everything because of Rule 39. Even J. Hatch agrees it's not absolute. Anybody looking at what Miss Beatty did would be like, outrageous, which is the standard that you need in Florida. So I loved that concurring opinion to be like, listen, although I agree with the majority opinion in this case, that was the main one we read. All hope is not lost. And that's what I want to end on, because there's going to be a lot of people that are mad. Hopefully, if you stuck with us till the end, that's crazy. Let me know in the comments. But all hope is not lost. And I hope that people will remember that and think about that as they watch through this video and we see how this continues. Now, listen, they can still settle the case. Obviously, the defense has all the leverage in the world. If I was handling this case and I was like, haha, I won, I'm not paying you anything or whatever it may be as a defense lawyer, once you get all the leverage, that's how you do. You use leverage in negotiations. They have all of it right now, but it's not over. We got to go, though. That's all we got. 2.5 hours is crazy long. It's got to be the longest podcast we've ever done. John, you did God's work today, reading through all of that. Thank you. I didn't have to do it. I still have a voice at the end. I was still able to jump in enough. Hopefully people didn't get too annoyed at me interrupting, because that was kind of the whole point of this. And I definitely think we need to do a follow-up Q&A, because your brain gets scrambled a little bit when you're reading 50 pages of documents reacting to things. So I'm sure you guys picked out a lot of what I didn't say or questions I didn't answer. Can't wait to talk to you about that more. If you want that, put it in the comments, hit the like button, subscribe, leave us a review on whatever podcast platform you're listening on. That's all we got. For John, for the lawyer you know, peace out. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.